Court Mombasa through the leadership of Justice Munyao, who was then the presiding judge, who really encouraged and pushed us and said, this, when we brought this baby to him, we told him we want the judiciary to run with this. But Justice Munyao told us, this is your baby, run with it. We will support you in whatever way you want. And that is why we see the judiciary here with us, because they are also fathers of this baby. So what do we intend to achieve as Greening Justice Workshop? We all know that environmental and land issues are best handled when all the stakeholders are involved. So this workshops aims to foster access to information, public participation, identify existing gaps in the current legislation, and promote access to justice through environmental courts and quasi-judicial bodies. The theme for this year is celebrating ELC at 10, as I had stated earlier. Njau and myself, together with MLS, that is Mombasa Law Society, Kituo cha Sheria, the ELC Court Mombasa, State Law Office, decided to come together this year in that spirit to celebrate ELC at 10, to bring all the stakeholders or various stakeholders to discuss environment and land issues affecting the development, future sustainability, concerns of advocates, and not just advocates, litigants, judicial officers, state and non-state actors in enhancing access to land and environmental justice. We intend to have such workshops as an ongoing conversation, not to just have it this year, but with all of us here today as we start this first workshop, to agree, to discuss and agree on how we are going to move forward to ensure that we have such activities on an annual basis or even quarterly basis. As one of the participants entered here, before she even know what the greening justice is, that is Miss Naomi, who's just seated in front here, she told me, Lillian, let this be an ongoing conversation. And she already volunteered. I want to be part of it. And that is the thing that we intend to do here. So all of us as stakeholders, how can we make environment and land issues resolve the issues that we are seeing? How can we all come together to resolve these issues? I therefore thank all of you as the various stakeholders for making it this possible and coming here today. And I welcome all of you. And I hope this is going to be an engaging discussion. And now I will want to just Miss Njau, who is online, just to say that is she's the other co-patron, maybe to say hello to the participants. Yes, you are. Thank you so much, Miss. So much, Miss. Now, as I said, our baby has many fathers. And one of the major father, we respectfully refer to our sponsor, not just a father, but a sponsor. This is Kituo cha Sheria. And Kituo cha Sheria are represented by Mr. Alan Nyange. Alan Nyange, maybe I can give you some time to just say a word.
Amjambo nyote, mtaniruhusu nichanganye ndimi na naomba kwa hisani mniruhusu nitumie lugha zote mbili. Wajua Kiswahili pia ni kigumu, sio chepesi sana, lakini kwa niaba ya kituo cha sheria ningependa kuwakaribisha katika hii siku moja, hii hafla fupi, na kwetu sisi hatuchukulii uwepo wenu hapa kuwa jambo la hivi hivi tu. Kwa shirika la kituo cha sheria sekta ama ishu za mashamba nafikiria ni ishu ambazo tumekuwa nazo kwa muda mrefu sana, na nafikiria ni issues ambazo sijui kama zitaweza kumalizika. Kile kitu ambacho tunaweza kufanya ni kuangalia njia nzuri ambazo zitahakikisha kwamba haki inapatikana. Sisi hususan walengwa wetu ni wale wananchi wadogo wadogo, wale ambao siku hizi wanaitwa mama mboga, hasla, yani kama ile bottom up approach yetu ni bottom up approach. So kwa niaba ya ofisi ningependa kuwashukuru nyote kwa hapa leo, na kwa niaba ya wageni wetu namuona Mheshimiwa Mburu yuko hapa, namkaribisha na namshukuru pia kwa uwepo wake hapa. Asante patron wetu convener ELC committee ya LSK. Asante.
If Alan says Kiswahili is difficult, I don't know what I'll say, and I'll not even attempt. Yes, the other father is Mombasa Law Society. Though I must apologize, our chair has not reached. He's a bit held up somewhere, but he will join us and we'll give him a chance when he does to say one or two to all of you. Now, we'll go straight in starting this workshop and we'll start with the first presentation. I'll therefore welcome Mr. Emmanuel Makuto, who is the State Counsel at the Attorney General's Office, to take us through the next session of the program. Thank you.
Hamjambo. Now, I wear many capes, but for today, I have an honor to introduce to us a distinguished gentleman, Mr. Griffin Ocheng, who has spent quite a considerable time in his life championing for chemical waste management in Kenya. He is the co-founder and executive director of the Center for Environment, Justice and Development, which is a public interest non-governmental organization that is championing chemical waste management in Kenya. Now, Kenya is part of the global village, and plastic waste is one of the many chemical wastes. Now, if you look at the data, we produce about 300 million tons of plastic waste in the world. And that number is growing at a rate of about 9% annually. This is something that has adverse effects on our environment. And in our country and globally, Mr. Griffiths has taken time in this fight to ensure that there is proper chemical waste management. He is also the co-chair of the IPEN, which is the International Pollutants Elimination Network, a plastic working group and a steering committee member of the International NGO Network. He is a founder, he is a former co-chair of the National Non-Governmental Organizations Major Group at the United Nations Environmental Program. Well, he has a long CV, and I may never do justice in introducing him. Allow me with
Allow me
the
with the
pleasure to
pleasure to
introduce Mr. Griffith, who will take us through this past
past
presentation
presentation
on
on
the
the
United
United
Nations
Nations
Resolution
Resolution
514
514
on the
on the
plastic
plastic
pollution.
pollution.
I will
I
welcome
will
us to
welcome
just
us to
have a
just have a
clap even
clap
as we
even as
welcome
we
him to
welcome
join
him to
us.
join
He will
us.
be
He will
joining
be
us
joining us
online.
online.
So,
So,
Mr.
Mr.
Griffith,
Griffith, you're
you're welcome
welcome
and
and
take
take this
this
opportunity.
opportunity. Karibu.
Karibu.
Thank you so much.
Yes, we can.
Yes, we can.
Thank you so much. And first, thanks so much for the introduction. Very grateful to be with you here today. And I must thank the organizers for having me here today to share with you the United Nations Environment Assembly is a land environmental challenge that is plastic. About the gap between enforcement, the commitment that the world made and the world will make again when when they complete the negotiation of the treaty, and the enforcement and the role that particularly for the audience, whom I know are mostly advocates, can play in safeguarding the right to a clean and healthy environment as enshrined in our constitution. So first, I just wanted to give you a background in terms of the evolution of the global policy response to this plastic pollution. So the issue of plastic pollution became significant and a big concern to the global community way back in 2014. This was the first United Nations Environment Assembly. This followed the upgrade of UNEP from a small meeting of member states, what Environmental Assembly, and the first meeting was held in 2014. So, and these meetings are held in Nairobi, being that we are the headquarters of the United Nations Environment Program. And in that, the global community, through a resolution which was submitted by one of the member states to address the issue of marine litter, which at the time was a big concern, particularly to those states in the bordering the ocean or have deriving their big economy. So at that time, this issue became.
Can you move the mic a bit away from your because it's popping a bit. The microphone.
Away. Oh, okay, thank you so much.
All right.
I hope it's better.
Yes.
Yeah, so at that time, it was agreed that the issue of plastic pollution, and particularly marine litter, is becoming a global emerging threat. However, there was no, that resolution was passed with that kind of conclusion. The second United Nations Environment Assembly, these meetings happen every 2 years when the assembly is held. It would agree that there is need to identify knowledge gaps that exist when it comes to the issue of marine litter. There were different understanding in such a negotiating setup where different countries, different states have different interests. So this was what was agreed that we need to know. Then in 2017, the following resolution meeting, it was agreed that through UNE Resolution 37, that there is a growing inefficient global governance, and then finding a common vision is important. This was a big meeting with the theme Beat Pollution, and it was well publicized in, through media, among other among other global community. And if you remember, this is the year that also Kenya, through a Gazette notice, which was given by the then Cabinet Secretary, Judy Wahungu. So this was also inconsistent with the need to ensure that pollution is reduced, particularly from plastic. However, that meeting also, there was already a group of countries that were calling for that we cannot have a national response to this problem. We need a global response. And that global response can only be given direction from United Nations Environment Assembly, which is the governing address the problem. So there were one hand those calling for legally binding instrument, and there are others who are saying this is a national issue. There's need to be addressed through improving national infrastructure for waste management, among others. So what happened is that at that meeting, the resolution that was adopted established an expert working group to be able to look at the issue in depth and the gaps that exist and ways on in terms of options that the follow global response. And then COVID happened in 2019, rather 2020. Just before that, there was the following United Nations Environment Assembly, where again another resolution was tabled, Resolution 46 in 2019. And that meeting also came with a proposal with a number of countries beginning to say that we need a global legally binding instrument. Though there were a bit of have a big presence of petrochemical industry and oil and gas presence who are looking at this issue as a threat to that economy. And so the resolution just extended the mandate of the working group so that it can be able to come and advise in the following UNEA in terms of response option that is needed, whether legally binding or voluntary measures. And there was also other processes which began, the G7 as well as the G20, Osaka Blue Vision, among other. Framing then was still around the issue of marine litter. Then COVID struck, and there was a bit of challenges in terms of convening the United Nations Environment Assembly virtually and meet an option of a new legally global agreement in their final report. So that was a game changer in terms of this expert group recommendation. Just before this was adopted, countries like Ghana, Ecuador, called the Interministerial Conference on Marine Litter and Plastic Pollution. At that time, many of the organizations, including ourselves, who are also part of what movement called Breakthrough from Plastic, were calling for a legally binding instrument. And in the engagement with member states, a number of countries and regions had already taken a stance that we cannot just have national response measures or regional measures. We need a globally binding instrument. And this meeting was more of the a consensus among many states and many regions towards the UNEA 5.2, which finally agreed to this landmark decision. So I will delve more deeper. If at the resolution, the scope of this problem was just realized that it is not just a problem in the marine ecosystem, but we also have a lot of plastic pollution on land. And so we don't need to have this as a marine litter, but call it plastic pollution in general, because we also which also face the challenge. Even though there was that evolution from the United Nations Environment Assembly, the Africa region also was not left behind in terms of convenings of the Africa Ministerial Conference on Environment. And this meeting called AMSEN, which brings together environment ministers, mainly been engaging on discussing the issues around biodiversity, climate change, among others, has not been on the political profile, higher profile when it comes to decisions of the AMSEN. However, with the growing threat of plastic pollution, in the conference which was held in Durban, South Africa in 2019, the ministers agreed and supported a global action to address the problem. In 2020, that is during the COVID online meeting, we know that there's a bit of background noise. Someone. Thank you. So we also have this regional agreement in Africa, which is called Bamako Convention on the ban on import into Africa and control of transboundary movement of hazardous waste. This is a regional convention by African governments to address the issue of importation of hazardous materials. And if you are probably familiar with the Basel Convention, which addresses the issue of transboundary movement of hazardous waste. So it was meant to strengthen that many of the global north countries, there's been a challenge of dumping in Africa. And then it was felt that the Basel Convention was not very responsive to the need of Africa. And in that meeting, they also agreed and recognized, and particularly in paragraph 6 of the decision, called for a legally binding instrument to address plastic pollution. Further, there was the momentum within the AMCEN, Africa Ministerial Conference on Environment, and in the online meetings due to the COVID pandemic at the time, supporting the resolution, which was eventually already been proposed in the ministerial conference that was organized in Geneva that I just mentioned, and was hosted by countries like Ghana. Rwanda, which is an African country, tabled a resolution which was marked as an ambitious resolution to address the issue of plastic pollution, together with Peru, which is in the Latin America. So this resolution got a lot of support at the UNEA 5.2, which eventually led to this. How it has been in the African region. And I will delve more into the resolution 5.14. But first, just to take you through just a treaty making process within or an international treaty. So we are here where we are still at the pre-negotiation. So just to clarify that the resolution is a mandate from the United Nations Environment Assembly to establish an intergovernmental negotiating committee to discuss and come up with a treaty. So we still don't have a treaty, but process to take place. So we are still at the exploratory phase, pre-negotiation, where there are a lot of information that member states need to have, including our country, Kenya, in order to negotiate from a very and come up with an international treaty. Then we get into a negotiation process, which has been mandated by the Assembly, the resolution, that has to be done within 2 years. Because of the growing threat of plastic pollution, many countries felt that ordinarily a treaty negotiation process takes almost more than 5 years, but we don't have that time action in the shortest time possible. So it's an ambitious resolution, a mandate that came from the United Nations Environment Assembly, that this has to be finished within 2 years. That is by 2024. And then after that, there will be a pre-implementation. So many state attorneys have to advise in terms of the signature and ratification of that treaty in compliance with necessary national laws. So you have a role. Once the treaty conference, there has to be it has to be opened for signatures. So every country will accede or put their signature that we commit to this global treaty, and we are ready to implement it as well as domesticate it into our national law. Then thereafter, the implementation phase, which is now as a convention, like we now have the conference of parties that will be agreed upon. How do they meet and make decision as an international treaty in terms of reporting, monitoring the progress, that among others. So we are still at the phase where we are at the pre-negotiation. And that's where we are getting to, and I will delve more deeper. So just to emphasize now on the resolution, this was the president of the UNEA at that time from Norway, and even it received a lot of recognition even from the United Nations General Secretary in terms of the adoption. So this was marked more or less like the following the Paris Agreement. This was the next that will be negotiated compared to that treaty of the Paris Agreement. So just to highlight a few takeaways in terms of the resolution. So the resolution requested the executive director of UNEP to convene intergovernmental negotiating committee, as I mentioned, which will negotiate the treaty, and it has to commence its work in the second half of 2022. So that has already been implemented. There's going to be the first intergovernmental negotiating committee. It will be the first meeting of this INC, but it has an ambition to complete its work by the end of 2024. This resolution also decided that this committee to develop an international legally binding instrument on plastic pollution. And just as I mentioned, the framing in the previous UNEAs were mainly on the issue of marine litter. But the scope of what this negotiation will look like was agreed in this resolution, that it need to be plastic pollution in all compartments of the environment that were keen to ensure that the emphasis is also on the marine environment, being that there's a big problem there. And then also just to highlight the issue of full life cycle, and I will talk more about that this negotiation has to have both binding and voluntary approaches. And this is based on a comprehensive approach that addresses the full life cycle of plastic. I will talk more about this full life cycle in the subsequent. So just to highlight a bit of the what is now called the mandate that came from UNEA. And the negotiation of the INC must stick to the mandate in order to achieve its work. And this mandate, specifically in paragraph 3 and 4, one talks about that the INC must come up with an objective of the instrument. So this is where we have to, I mean, it will take a bit of negotiation about what is the objective. There's one hand of states talking about that the objective. We've heard about research talking about plastic, microplastic found in breast milk, plastics in blood. So to what extent do we want this instrument in terms of its objective? Does it cover the protection of human health and environment, or will we be able to have an instrument that talks about management of waste, which is the end life or end of life kind of, if you look at the life cycle of plastic itself. Then it also talks about promoting sustainable production and consumption. And I just want to highlight a few that I find very that is brought to you when it comes to environmental challenges. One is on the issue of sustainable consumption and production, but looking at the product design. So when we talk about plastic, how is it designed? Is it designed for recyclability? Is it designed with toxic chemicals in it? When it comes to the plastic as a product and as a material, what are the polymers and how are those particularly eventually in the methods of disposal exposes human health and environment. This is a big focus of the negotiation, that to address the plastic pollution from upstream at the production phase, there has to be the issue of product design that the industry or the manufacturers need to take into consideration, because at the current state, most plastics are not designed for recyclability. And that's a big issue when it comes to threat of plastic pollution. Then the other that I want to highlight is that this focus must also focus on environmentally sound management. So what is proposals or different types of ways on which is proposed for managing waste, for instance. We've heard about waste to energy plants, we've heard about incineration, we've heard about many other cement kilns, chemical recycling. All these technologies are being promoted by a number of pro-plastic users, whereas those who are public interest organizations like us are not really keen on those kind of technologies, because if into the environment, for instance, another convention of the UN, which is called Stockholm Convention on Persistent Organic Pollutants, look at the issue of dioxins and furans, which is a type of long and persistent organic chemicals that are a big threat to human health and the environment. So when, for instance, a state or a municipality wants to put up a waste to energy plant, for instance, public interest organization may come and litigate and say technology that is environmentally sound, and we want to ensure that inconsistent with the articles of the Constitution, this is not something that the judges need to agree in the interest of the public. So these are kind of areas that you can take very keen interest in understanding the issue of plastic pollution when it comes to. I will not talk much. I may also just highlight the issues of national action plans that has to be developed in order to prevent, reduce, and eliminate plastic pollution. already ratified, one of the obligations, if you look at the legally binding measures, is the issue of coming up with a national action plan, similar to what we now have in the climate change called national determined NDCs. So we will have that kind of action plan that a country, for instance, like Kenya, must develop in order to track how they are addressing the issue of plastic pollution, including the issue of reporting, which is our obligations to the states to be able to report and monitoring the implementation of such as mechanism that is needed to be able to be adopted. Most of these convention or treaties have the Global Environment Facility, which is a trust fund implementing them. However, many states have challenges in accessing that funding. So one of the options that is to be decided by the INC is a dedicated multilateral fund, for instance, like the Montreal Fund, which is implementing the Montreal Convention on ozone it's been regarded as successful in eliminating the ozone depleting substances, particularly in fridges, and it has a dedicated multilateral fund that help its implementation. So this is very important, particularly for the Africa region. So in the road ahead, which I will also talk about, to achieve this 2024 timeline is that there has to be a meeting. We are talking about the second half of 2022, which I've talked about, and then also a meeting in April next year, just the first half of 2023. Is a United Nations Environment Assembly 6 that is in between. And so the resolution mandated the INC to report, or the executive director to report to the UNEA 6 on the progress of the negotiation. So that's something that will be done if they do not complete their work by 2024 or before that. Just in preparation for the first INC, there was a working group meeting that was convened in May in Dakar, just to be able to guide the member states in negotiating this treaty. Where do we start? Where is the starting point? What documents do we need? What do we need to understand around the issue of plastic? So that in negotiating from a national perspective, from a regional perspective, there is some kind of approach or structure on how the negotiation which negotiation will follow. And this glossary of terms, or rather the documents that you can see on the right, are what was proposed that the United Nations Environment Program Secretariat must develop to guide the member states. So these are what we call the working. Just to highlight, it has the issue of, for instance, plastic science. What is the monitoring? What are the sources? What are the pathways? I had the moderator talk about, for instance, the quantity of plastic that we produce. All those has to be prepared for the member states to be guided on how they are going to negotiate, including priorities, among others, and also existing agreements that are there. We have a lot of agreements that touches on the issue of pollution, the CBD convention, among others. So I will not dwell much. I've talked about this. This is just a clear timeline that was adopted by the open-ended working group, and you can see just like I presented earlier. I talked about the full life cycle, and I just want to give you this illustration from our viewpoint, what we see as a plastic life cycle. I know that many organizations or many countries look at the issue of plastic from plastic waste management, but I want to just to show you this oil and gas. So it starts at the extraction phase. So countries that have big oil and gas sector, they convert that oil and gas into making plastic. And that's where the genesis of the problem is. And this is not particularly for Africa, because we don't have a big presence of the extraction compared to the global north countries. Then we do have the production phase, where we have now the plastic being produced, the polymers, the virgin plastic, the chemical additives that are added to make it what it is in terms of food packaging, types of plastics. Then we now have the use, where you do have the, for instance, you get your plastic bottle from the supermarket, you can see. Then now we issue of recycling, which is promoted as addressing the problem. But we see that in order to have a safe recycling or circular economy, as currently being discussed in many places, that circular economy must be free of toxic chemicals. So we cannot recycle these additives that are mainly added, and many of them are found to be and affect the reproductive and other human health aspects. So these toxic chemicals, many of them, need to be eliminated from this phase of circular economy. Then now what I talked about, the issue of different types of disposal, where we now have to be keen on the issue of environmentally sound disposal that you can be able to address. Then we also have the issue of global waste dumping, mainly from the global north, to be able to ship their plastic waste and other waste for recycling. The year 2021, I believe, or 2020, we particularly raised a big concern in the negotiation of the free trade agreement that Kenya was negotiating with the then US administration, the Donald Trump administration, that the expose was released from the New York Times, where many of the American Chemistry Council members, that is the big petrochemical companies, were proposing to export plastic waste and chemicals in order to address the problem. And this was a big concern when it comes to how do we control our borders to the issue of plastic waste trade. And I think this is an area that you have a role to play in terms of looking at the negotiation of this agreement, the legal agreement around it. How do they comply with the necessary or the laws that the country has already ratified, like the Basel Convention, among others, in order to protect the environment and the human health. So with that, I thank you very much.
Thank you very much. Maybe I will request Mr. Griffiths to remain online a bit. I think those of us who have questions from his presentations, I will request that you will hold on to the questions a bit so that we have the next speaker. Mr. Nyange will take the opportunity to invite the next speaker, and then we'll have a plenary session.
The next speaker is joining us virtually. Is Mr. Mohamed Balala. Mr. Mohamed Balala is known to almost all of us. He's a senior partner at Balala and Abed Company Advocates. I think he's been practicing law. He qualifies as a senior member of the bar. He has interests in the land and environment sector. Mr. Balala has also been our chair, and Mombasa past chairs are referred to as ancestors. So he's been a chair of Mombasa Law Society. But for today's session, he is joining us in his capacity as the chair of the National Environment Tribunal. He's been a member of the National Environment Tribunal from the year 2016 to date. So, ladies and gentlemen, allow me to welcome Mr. Balala to give us his thoughts. Thank you.
Maybe Mr. Balala, before you go, I have a request from Mr. Griffin. He has 10 more minutes. So you could just give me 10 more minutes so that Mr. Griffin can take questions if we have any questions in the plenary, because we don't seem to have them online. With your kind permission, do we have any questions for Mr. Griffith? Yes.
Good morning. Thank you so much, Mr. Griffin, for that presentation. I just wanted to ask, within our regional economic bloc, the East Africa community, is there any policy frameworks that can be used to advocate to fast track the plastic waste management, or are there policy advocacy spaces that then people working within the area of environmental conservation can use to push our partner states to enhance issues to do with coming up with policies to enhance plastic waste management? Thank you.
Any other question? Mr. Griffiths, it looks like you did a good job. I think you can take that question.
Yes, I was inquiring about the opportunities within the regional economic bloc, the ESC, legal frameworks that can help advance issues of plastic waste management.
To guide all the regional member states.
I think that is a good answer that addresses your question. Thank you very much. Allow me just so that we can say thank you to Mr. Griffin before Mr. Balala join us. I think he has done a good work. You all agree with me, right? I will propose we give him showers. All of us know what showers is. I will show you what that means. Thank you very much. You note that as a, thank you very much. Thank you, Mr. Griffith. For those who have provided the emails, the presentation will also be shared with you. You have also taken part in ensuring there's no noise pollution. Now, allow me, with your permission, then to have an opportunity, and I get the opportunity to then introduce two people. Mr. Balala can then join us. Thank you very much. Mr.
Balala, you can go ahead.
Thank you very much. Good morning to everyone, and I hope you can all hear me clearly. I'm in some remote place, and I hope the network will not let me down. Thank you very much to the initiative in this matter that has invited us. The Greening Justice I've been asked today to speak about access to justice, in particular, access to justice at the tribunal, to the tribunals. And to begin with, I would like to first greet the judges of the ELC of Kenya who are in attendance today, and distinguished lawyers. Begin with a quote from a leading conservationist. His name was John James Odban. He had said that a true conservationist is a man who knows that the world is not given by his fathers, but borrowed from his children. So that we all have the responsibility to build today for the children of tomorrow. With that in mind, environmental law has come a long way. It was not even recognized as a category of law and throughout then an evolution began to introduce environmental law and to bring it into the mainstream of the legal practice. 30 years ago in 1992, members of the
it's not too late. It's not too late.
And people mute.
Yeah, if maybe the admin can mute, and then I can continue. Members of the international community converged in Rio de Janeiro in Brazil, and they came up with principles of environmental law and protection. It's commonly known as the Rio Declaration on Environment and Development. In 1999, 7 years after the Rio Declaration, Kenya then domesticated principles that came out of the Rio Declaration into law by enactment of the Environmental Management and Coordination Act, which we now call EMCA. As to how we come to access to justice within the tribunals, this short historical background. So Principle 10 of the Rio Declaration required that states would inter alia facilitate effective access to judicial and administrative proceedings, including redress and remedy. This is the backbone of access to justice within for the tribunals. Of course, the Rio Declaration, Principle 10, came up with 3 principles that carry with us whenever we're thinking about administration of environmental justice. And these 3 fundamental principles and rights, the first one was access to information, the second was access to public participation, and the third was access to justice. And these form the key pillars of sound environmental governance. So all these principles have been captured in EMCA, and for the purpose of our talk today, that arises out of Principle 10. So when EMCA was enacted, Section 125 of EMCA created NET, which is the National Environment Tribunal. And that is the tribunal I believe we're talking about. I have been the chair of the tribunal for the last 6 years. It's a tough job, but actually very enlightening and education. And it presents a lot of opportunity to see a different part of the legal practice and opportunities that can be created there. So when NET was created, or the tribunal, there was a confusion amongst, and continues to exist, that this tribunal is a NEMA tribunal, that it falls under NEMA. In fact, very commonly, we are often referred to as the NEMA Tribunal. And of course, this is not correct because the National Tribunal, it is supposed to examine and sit on appeals from decisions of NEMA. So whether NEMA during the licensing process or the decisions of the Director General or any organs of NEMA are then appealable to the National Environment Tribunal. So the National Environment Tribunal historically was constituted in 2002. The rules were promulgated, rules that govern the tribunal to date. The tribunal's jurisdiction, as I said, is essentially to sit on the decisions of NEMA, firstly, with respect to licensing, that's under Section 129.1, and then Section 129.2 expands the jurisdiction to other decisions of the Director General and the organs of NEMA. Since then, other statutes, for example, the Forestry Management and Management Act, have also referred decisions made by those organs, the Kenya Forest Service and the organs under the Wildlife Conservation and Management. Those decisions are also appealable to NEMA. So you find that the National Environment Tribunal now has jurisdiction not only with respect to licensing and other decisions of NEMA within MCA, but also of the Kenya Wildlife Conservation and Compensation Committee. These are the areas where the tribunal's jurisdiction has expanded. Now, having been formed in 2002, 2003, in 2010, of course, we all know the Constitution of Kenya came into being. The Constitution of Kenya is a very robust document, and it was one of the first constitutions to add into the Constitution. It ensured recognition of fundamental right to a healthy and productive life in harmony with nature. And that is contained in Article 42, which talks about guaranteeing a right to clean and healthy environment for all. So I would encourage all the participants to read Article 42 of our Constitution, together with Chapter 5, Part 2 of the Constitution, that has set aside entire sections and chapters to deal with environment in respect of those environmental protection. So the constitutional backing for environmental law has already been captured, but with respect to the access to justice, that is the tribunal itself, Article 169(1)(d) then says that as part of the judicial setup, the tribunals will be deemed one of the subordinate courts. So that the National Environment Tribunal and any tribunals to deal with environmental matters now become part of the judicial process within the country. And in addition, of course, for access to justice, and that is something, I think, a topic that His Lordship Justice Nekune will be coming to talk about later, is also the creation of the Environment and Land Court under Article 162. So these are all bodies formed satisfy the access to justice requirement of Rio Declaration. Now, can you come to the National Environment Tribunal? Can you go to the High Court, go to any other body? Of course, we know that the High Court, the ELC, especially in respect of environmental matters, have original inherent jurisdiction to deal with matters. So there was a tendency of people going to different bodies. Of course, the Fair Administrations Action Act actually was an enactment of principles of law that were already being stated by courts before then. And the Fair Administrative Action Act came up to say that tribunals, like the National Environment Tribunal, enjoy important status as the first port of call for institutions in resolution of disputes in environmental matters. So Section 9.2 of the Act states that the High Court shall not review an administrative action, appeal or review, and all remedies available under any other written law are first exhausted. So what that meant is that because the National Environment Tribunal is cemented in MCA, then your first port of call would be to the National Environment Tribunal if there's a grievance on the mandate of the tribunal under MCA. This principle has been restated by the Supreme Court itself in the Kibos Sugar decision and is the locus classicus on this matter, so that it directed that all disputes touching on decisions of NEMA and MCA should first be instituted at NET, and requiring the higher court to exercise restraint from the exercise of their jurisdiction. So that is the importance of the tribunals in the access to justice framework of the law. And in doing this, Kenya, of its international environmental obligations insofar as access to justice is concerned. Now, when you look at the efforts made by the tribunal in, what is the importance of the tribunal in the importance of the tribunal in access to justice framework, you will see the National Environment Tribunal reduced pressures on the court system, thus enabling expeditious management of disputes and to deal with specialized matters under the different statutes mentioned. And not only that, the National Environment Tribunal has played a significant role towards sustainable development in the use of natural resources. It has adjudicated matters that touch on the EA licensing processes across a vast field. That is to include, to consider industry and residential estates and industries close to each other, who gives way, how, what considerations have to be put into place. It has had to adjudicate on cases of disposal of hazardous waste. It has confirmed the principles of effective public participation in environmental governance, like in the Lamu coal case. It has had to consider climate change, dealing with an appeal on the expressway, the Nairobi Expressway, and in fact has gone further to make orders that climate change has to be instituted. Climate change processes have to be instituted so far as the expressway is concerned. It has had to look at air, noise, and waste pollution, and this are to list by a few. And some of the decisions have been cited both nationally, internationally, and we believe has gone a long way in enriching the. Now, as part of the tribunal's mandate for greater access to justice, the tribunal has endeavored to not only make the proceedings accessible through virtual open hearings, like in this case, so that from 2020, there was an immediate shift to virtual hearings. In fact, it was one of the first institutions that moved to virtual open hearings as a way to have access to justice. So it has to mean that the process has to be affordable. And to that end, the tribunal does not charge any fees. So there are no filing fees in the National Environment Tribunal as part of the efforts to make it accessible. There's no undue requirements as to procedure, so that complaints are in a simple format. The registry staff are encouraged to guide parties in how to arrange. The tribunal exercises its jurisdiction based on the forms that are filled in and the proceedings that are brought before it. The other part is that the tribunal has an effective case management system so that it allows matters to move expeditiously with minimal adjournments. Adjournments are usually at the behest of parties rather than of the tribunal itself. And of course, as part of the dispute resolution as a means in many instances to achieving mutually acceptable outcomes. Now, the tribunal's jurisdiction is not without limitation. That's an important thing to know, because many people, whenever an issue arises, wonder why doesn't the tribunal step in and do something about it? Firstly, the tribunal's mandate is not its powers were not, and it's essentially an appellate tribunal. So it's an appeal from the decisions of NEMA or from the decisions of the DG or its organs. The tribunal cannot do anything without being moved by the parties through an appeal process. So that is the first limitation. The second limitation is that of time. All 90 days from the date of the decision. And this is so the time limitation, it affects certain the time limitation affects certain persons who come out of time whenever a decision is made, has the potential of causing injustice, of course. And the third is that it does not cover every environmental issue. It only covers decisions of NEMA in the licensing issue and the decisions of the Director General of NEMA and the respective organs. It does not have jurisdiction in all environmental matters. So these are some of the challenges faced and some of the limitations that the tribunal carries with it. Given 30 minutes to make the presentation, but I thought that the tea break coming next would be important for us to summarize the presentation today. Yes. So thank you very much.
Yeah, we can applaud. I am to be guided whether we can do a quick round of questions. Is that okay? Yes, there it is. Questions to our very able chair and member of Mombasa Law Society.
I just wanted to correct one statement I made. Sorry, I had said 90 days was the limitation. It's actually 60 days. Effect of 129.1 is strictly 60 days without an opportunity for extension. And appeals under 129.2 are 60 days, but capable of extension.
Thank you.
So that's a small correction to make. And I'll be happy to answer any questions anyone may have.
Members, any question? We've never been practitioners to this tribunal, have we? And the decisions are reported. Almost all the decisions are reported. Mr. Makuto, no question from you. You are satisfied. I think members are eager to go for tea break. They have no questions, it appears. Chair, I have questions for myself. you've spoken about the expanded jurisdiction. I think that is new to me. I would be interested to find out the nature of the issues from the forest department and maybe from the Ministry of Wildlife and Conservation. What would be the kind of issues that I would get and approach the tribunal? Because the normal usual issues we all understand are to do with the licensing processes. Now that the jurisdiction is expanded, what are the issues that the tribunal can now exercise its jurisdiction on? That is one. And the second is on issues of enforceability. How do we then enforce? Can I come to the tribunal and make an application for contempt or for enforcement? As is usually the case with many tribunals, we have to go to the usual courts for enforcement. And I think the last question is whether in all sittings of the tribunal the chair has to be there, or the law allows for you to empanel yourselves, maybe 3 people, or you must sit as the entire membership for the court to be properly constituted. Thank you, Chair.
I think those are many questions, but I'll try to summarize them. Of the tribunal itself. The tribunal is meant to have 6 members appointed to form the tribunal, and to be, of course, then chaired by a chairperson. The quorum of the tribunal is 3 persons. In all sittings, the chairperson has to sit. So in as much as you may have different panels, the chairperson is required. That is a requirement of the law. The present arrangement is that there are only 5 appointments that have been made. And there was always a 6th slot left that has never been filled for some reason. We don't understand. But for those who have practiced before the tribunal, you will find that we have had as a practice on very rare occasions do we have a situation where the tribunal does not sit as a full panel. And that arises maybe if one member is indisposed, then the other members continue. And also where a party feels there's a conflict of interest, the tribunal member will recuse himself. And this has taken place in some matters where members have recused. As regards the matters or the expanded mandate of the tribunal, you have appeals from the decision of the Ministerial Wildlife and Conservation Committee. The Ministerial Wildlife and Conservation Committee is an organ formed to deal with appeals from injury or damage or death by animals. So where wild animals kill people, then there's a process by which they can claim compensation to the committee itself, the compensation committee. The committee then makes a determination as to whether to allow or not to allow, and if any party is aggrieved, an appeal is then filed to the National Environment Tribunal. The National Environment Tribunal at that juncture will hear the appeal, consider the compensation accept the decision of the compensation committee or replace the decision of the compensation committee by a decision itself awarding compensation if it sees fit, or enhancing the compensation. The compensation for wildlife injuries is provided in a schedule to the Wildlife Conservation Management Act. It keeps on changing from time to time. So someone always has to know when the injury took place and when injuries. Snake bites is very common from coast region. We have a lot of cases coming out from the coast and northeastern provinces with respect to to snake bites, resulting either in injury or in death. So that's one aspect under the wildlife laws. In the Kenya forestry management, we have situations where we have dealt with forest agreements where in Ngong Hills, for example, there was there was an agreement between the Kenya Forest Service and the proponent of the project. And as a result of a failure in the agreement or a default in the agreement, that matter came before the tribunal for termination. Also, you have situations where there's farming within forests with the permission of the Kenya Forest Service, and where there's a dispute as to who and Mohad. So those are some of the instances in that expanded jurisdiction where such incidents have arisen. I hope that answers the question. Now, the good news to those practitioners who are here, the term of the tribunal has come to an end, essentially. And there are opportunities for lawyers to then, through the Law Society of Kenya, tribunal, by virtue of the slots given to the Law Society of Kenya. Not every member of the tribunal has to be a lawyer, but slots have been given to the Law Society of Kenya. And I would encourage all members here who are interested in this area of law to pursue such opportunity. We have also, I think, noticed that in matters before the National Environment Tribunal, because it is not pecuniary jurisdiction or regional jurisdiction, you find that it is a good forum to go adjudicate on matters that can be dealt with quickly without regard to pecuniary jurisdiction. So that the jurisdiction of the tribunal are dealing with subject matters of over 100 million, hundreds of millions, and in many instances up to billions of shillings. And of course, for practitioners, that may be worth exploring. And in doing so, the lawyers who come
thank you. I have a question. On bread and butter issues, speaking of the wildlife committees, where are they situated, located, what is the composition? And then is the tribunal mandated to handle criminal cases? Because the issues of wildlife hunting, you have to have a license for you to carry out the wildlife hunt. So in the cases where you hunt on wildlife and you do not have a license, that becomes a criminal issue. Does the tribunal has jurisdiction to handle such matters? Okay, my question goes to chair of the tribunal and my senior. On bread and butter issues, you've talked about the wildlife committees. That they are the first, hold the original jurisdictions on matters human wildlife conflict. So my question is, I have handled matters in Voi where there's a lot of this human wildlife conflict. Where are these committees situated? What is their composition? How can we reach them? And then on the issue of the
wildlife
wildlife
hunt,
hunt, is the
is the
tribunal
tribunal
mandated to handle
criminal
cases?
cases?
Because in my
Because in my
understanding,
understanding, for you to hunt a
you need to have
wildlife,
a
you need to have a
license,
license,
such that
such
if you
that if
hunt
you
on
hunt
wildlife
on
without a
wildlife
license,
without a
then that
license, then
becomes a
that becomes
criminal
a criminal
issue. So
issue.
that the
So that the
tribunal has
tribunal has
jurisdiction to handle.
We have one question from M. Owea. It's on the chat box as well. Sorry, I'm just trying to find it. Mr. Owea asks, Chair has stated that the proceedings have to be finalized within 60 days. Seeing that it is one tribunal handling matters all over Kenya, is 60 days enough, or the tribunal has to hurry its proceedings? That's one question from Mr. Owea. The second question is, does a complaint before NET act as an automatic injunction in case of a construction? If so, in such an instance, how does the tribunal ensure the interests of the developer are protected, noting that the 60 days injunction is well, the question is right there on the chart. Is costly to a construction. Yes, that's the ending. Is costly to a construction. And lastly, Teresia Memia asks, are there costs awarded in where the case is a public interest?
tribunal. Now the question came, what happens with does filing of an appeal to the tribunal then come with an injunction? Yes, section 129.4 of the tribunal is one of the most hotly contested provisions of the law. It has been the subject of review or attempted review. It has never succeeded due to court cases that have stopped the implementation of the amendments. But section 129.4 says that when an appeal is filed to the tribunal, there's an automatic stay. If it's construction works, they have to stop. Anything has to stop pending. And this is the thing. It says pending the hearing and determination of the appeal itself. So if the appeal takes 6 months to conclude, then of course, there may be injustice done to the developers or to the project proponents in the event that they win. So that possibility of injustice is there. The tribunal over the 6 years made proposals to the Law Reform Commissions to say that this provision may be instead of making it automatic, there should be discretion given to the tribunal to either grant orders of injunction or stop orders, or in some cases, then not give it if it's not merited. In 1997, in 2017, 2018, amendments were made to the law, to MCA, which then made that provision discretionary. So the tribunal at that juncture was supposed to exercise discretion and give. Had public interest groups that rushed back to the tribunal, that rushed to the Constitutional Court and obtained orders staying the implementation of those provisions of section 129.4. So as it stands today, there's court orders stopping implementation of those amendments, the effect of which is that now the automatic stay order is still in place with the risk of injustice being caused to parties, of course. Yes, the tribunal does award costs in instances where we feel costs ought to be awarded. They are not awarded as a matter of course. In public interest litigation, they are not awarded. So that is the other aspect to consider. There was a question that may have misunderstood what I had said about the 60 days. That says that if pressure on the tribunal, no, that's not what I suggested. What I said is that you have to file your appeal within 60 days. It is not 60 days for the tribunal to make a decision. It is within 60 days the appeal has to be filed. And then it will be put for mention, directions will be given on filing of responses, etc., etc. In many instances, people file preliminary objections on the basis that an appeal has been filed out of time or it's in the wrong forum. Not everything falls under EA license. Some things are physical planning issues. So some people may file an appeal to NET, believing that NET has the powers to stop anything. But it may not really be an environmental issue. It may be a zoning issue, a physical planning issue, in which case then the tribunal has no jurisdiction but to refer it to a physical planning committee, or if it does not exist, to the ELC. Out on any question? Moderator, can you assist?
Senior, there's one more question. From Jao. She asks, please share the international cases where the tribunal's decisions have been cited, e.g. the Cole case.
Yes. Now, the tribunal's decisions are online. Are online in the Kenya Law Reports. They are reported, most of them. And some have gone on appeal because most of our decisions, all our decisions are appealable. So that is on a happier note that we're not the final port of call. we're as the first port of call, but not the final port of call. So, of course, we do make decisions that are sometimes appealed, sometimes are upheld in our decisions, and that happens. But those decisions, as part of the access to justice, we have over the years insisted that those decisions are published in the Kenya law reports. So they form as a guideline for people who want to file proceedings at the tribunal. Yes, they have been cited internationally, and I will try to get those decisions and send them over to. Anything else?
Thank you.
Thank you.
We want to wish you a nice day. I think members are happy and they're satisfied. Maybe we can do what they call showers, because we don't want to pollute the environment with noise. Mr. Makuto has shown us a good way of applauding without polluting the environment. Maybe showers for our speaker. Thank you, Senior. Have a nice day.
Thank you very much. Thank you very much.
Thank you so much, Alan Yange. Thank you so much, Senior Mohamed Balala, Grievings Ochieng, and Emmanuel Makuto. Now, before we have our tea, I will just want to recognize a few of the members of the participants who have joined us. Ambassador Joachim Kamere. Ambassador Joachim Kamere is the deputy to His Excellency Manoa Esipisu, and he has joined us online. Thank you and welcome. I'd also like to recognize the presence of our ancestor Benjamin Njoroge, who has joined us online. Benjamin Njoroge is a former chairman of Mombasa Law Society and an ancestor to many lawyers here in Mombasa. And Bosco Juma. Bosco Juma is the founder of Big Ship and executive director. Perhaps Bosco, you can just wave to the participants where you are. Thank you. Daniel Maina, founder of Kisiwani Conservation Network. Thank you, Daniel, and Karibu. And Janet, Miss Janet Langat, the regional head of Office of the Attorney General, Department of Justice. Karibu, Janet. And of course, our Honorable Judge, Justice Mwanyale, all the way from Kapsabet. Justice Mwanyale, just wave to the participants and Karibu. Yes. With that now, I know most of you, your stomach must be rumbling and we need to have something before we come back. I know our participants who complained immediately she came in that she's very hungry. But thank you for making it on time. I will not mention your name. So now, before we go for tea, I've noticed that most of us, when we want to use the washroom, we are going outside. You don't need to go outside. Just on my, this is right or left? On my left, just a far end there, the washrooms are there, so we don't need to go out. So right now, we'll just proceed for tea downstairs. There'll be someone who will guide you from there. Thank you so much, and let's be back in 30 minutes. Tea break is 30 minutes for our next session by the judges. Thank you. No one is clapping for me.
Check 1 2. Check 1 2. Check 1 2. Check check check.
Good morning once again. Allow me just to recognize some of I'd mentioned to you earlier that Greening Justice has many fathers. So some of the fathers of Greening Justice have joined us. This is Honorable Justice Naikuni, karibu sana. Honorable Justice Naikuni, Honorable Kiage, karibu. And of course the other father, our chair, Mr. Charles Opulu, karibu. Yes. Now I will go ahead to introduce our next speaker, who is a distinguished judge and was born in the county of Narok. He attended Ole Sankale Primary School at Narok, Ole Leza, and Ruiru High School for the ordinary and advanced secondary school levels. He joined the Punjab University and University of New Delhi, where he undertook both Bachelor of Arts degrees in sociology, public administration, and political science and law. Thereafter, he joined the Kenya School of Law, where he attained a diploma in law. He worked at Iseme Kamau and Maema Advocates, Moitalel Olekenta Advocate as an associate for a while. He then was employed by the National Council of NGOs as the Program Legal Affairs Officer. Thereafter, he was promoted to the position of the National Coordinator, Civic Education. He left to establish his own law firm of Messrs. Naikuni, Nga, and Miencha and Company Advocates, where he worked as the managing partner for 22 years. He was appointed a judge in the Environment and Land Court on 3rd June 2021. Justice Naikuni will take us through the next topic for today, which is balancing the right to peaceful use and enjoyment of property, issues of squatter rights and proprietor rights, an issue that is so major in the coast. And I'm sure most of you, I speak for myself and many of us here, are really interested to learn that. And I'm sure that Justice Naikuni will shed more light on that particular topic. Justice Naikuni, karibu sana.
Thank you very much, Council Lillian Wambi, for that very incisive introduction. I don't know where you got my background from, but I congratulate you for that. That means I'm quite exposed. Nonetheless, in the spirit of Article 10 of accountability, transparency, that's the way to go. Before I proceed, I have some disclaimer. One is that this technology has not been very kind to us, so we may not be able to enjoy the slides all the way through towards the conclusion of the presentation. So you'll forgive me if I go to the traditional way of presenting. The second disclaimer is that I am not a guru in the subject I'm about to present. I'm actually informed by the fact that I am preaching to the converted, and therefore there's no magic. It's just, I would have even wished if it was more of an interaction, a discourse, so that we are sharing back to back. But all said and done, I have a job to do, and who am I but to perform it? My task has been to create a balance between a subject I actually enjoy, a subject that is interesting to all of us, particularly all the practitioners, and more so here in Mombasa, coastal region. And this is a subject of, you're looking at the propriety rights on one side, what is stipulated by the statutes. And again, we are also looking at the new, I'll call it the new invention of jurisprudence, where there are a class of people who are among us in the midst of the society, and they find themselves, because of the organic evolvement of history, it's not their choice, but there are people who, a sector that has not been addressed critically as far as the utilization of land is concerned, but they are there and they require to enjoy their rights within the purview of the Constitution and the land laws that we have. And those are the ones that I'm going to give them. They have quite a number of names that are used, but we'll see. Virtually everybody understands that land is a very emotive issue, economically, politically, and socially, and that comes all the way from the history to where we are right now. And I was saying that if there is a community that has been affected adversely by historical injustices, it is the coastal indigenous people and the pastoralist community where I come from. But I thought the Maasai community were adversely affected by land injustices until I came to the coast, and I'm confessing this. People here have problems, and these problems are real. And unless and until we are able to resolve these issues as practitioners, one said that the land issue in the coastal region is a time bomb, and unless it is defined quickly, it's likely to explode. We have the blessing of the Constitution, and of course the other institutions that have come along with it, the National Land Commission and the Environment Land Court, and the land policies that have been enacted. So basically, this presentation will be looking at that dimension. I'm just giving you the overview of what, and then in terms of what rights do these squatters, or rather the tenant at will, or people who do not have legal attachment, strictly speaking, statutorily, what do they have to say? What do they have to take home as against the people with the titles and so forth? So when I'm looking at land, I'm not just looking at the land, the surface, it's the land up and below. So we'll also be looking at the mining rights and so forth. Now, the definition of squatters is people or someone who has settled on or occupies a property or building which legally belongs to another person or institution without claim or without the consent of that person. I have said that when I was preparing, not strictly speaking the squatter, but I'm also looking at what is this that has brought this institution or this classification of people. And I'm saying that there is a group called absentee landlords. They are landlords, but they have created a structure called tenants at will, or people on land, but without a legal thing to hold on. And you find that the absentee landlords are people, if somebody has acquired land, but it doesn't occupy, and he lives elsewhere. He's doing his other businesses, but he leaves somebody to take care of that land called an agent. And this agent sometimes they're self-appointed, and they subsume legal rights or roles which is not structured, so to speak. And if you look at the history, and I'll be looking at that slightly at a later stage, is that this is a creation of our own enactment, the Land Titles Ordinance of 1908, which I'll on it. vis-a-vis Section 21 of that particular act. This finds ourselves the coastal region to where they are at the moment. So these agents take the rights and they are paid. They collect some little money, they call it Ijara or Kilemba. Yesterday I was told a new term in court called Mukate. So, and it's as little as 200 shillings a month, 500 and so forth. You continue, and I'm spending a bit of time on this because you found yourself on that parcel of land because of customary rights. But you continue living, you continue assuming you have the ownership, and then you build, you even construct, you put up structures, and at times the owner knows, at times the owner does not know. And that's now where the main distinction comes in. They're also known as tenants at will. These are different terminologies described by different statutes. Again, living without the consent. And the difference here is that the tenancy can be terminated anytime. The owner can come tomorrow and say, stop it, and you go. And we are all familiar with this. The Isaac Morito's case, a very famous case for those who did history and so forth. Then there's an aspect of the idle land, a land that has been kept, is not being utilized. The owner is not there, he's gone, and the land is fallow. And now, as a result of all this conceptualization, because it's important, is that these persons continue living on the land continuously for a long period of time. They construct, they put structures on the surface. They are not disturbed. They continue paying Ijara, they continue paying Kilemba, they continue paying whatever else they call it. And now, when the time comes to termination, the lease, or asking them to leave, problem now begins because they say, how do we live when we do not have registrable lease? So this new concept, and I've really struggled to understand, house without land, it actually emanates from that connotation, and it's found in section 3851 and 106 of the Transfer of Land Act. And shamba, nyumba bila shamba, or house without land, is a concept that the Court of Appeal in Malindi, Justice Ouko, tried to define in the case of Omau Mwenyewe and 19 others, where described that the dispute arises from the land tenure unique to Mombasa, which has baffled scholars, practitioners, even jurists. The land system is only referred to as house without land. That is, the owner of the house is different from the owner of the land on which it stands. It therefore defies the common law concept of land expression and so forth. Sorry, you are now punished. You're not able to follow the slides there. So that that is as far as the concept is concerned of the squatter. Now, looking at the history, the coastal people, like all the other Kenyans, found themselves where they are from the enactment of the what you call the Foreign Jurisdiction Act of 1890, where the colonial extended their powers to East Africa, and therefore the Land Titles Ordinance Act was enacted on 30th of November 1908. Now, what is the most important thing about this ordinance is that it gave the land registration officer power to declare an unalienated land as unclaimed, but they gave people notice of about 6 months or something for them to make claims on land. That period, upon some people they reacted, mostly those who were aware, the Europeans, because they're trying to excite, they're trying to make the Europeans develop interest on land. So Europeans, Arabs, Indians did respond. But the indigenous people, one, they were not even aware of what was going on, of course. They did not even understand the import of the ordinance. So for those who did not claim, they found themselves to where they are. And for those who claimed, of course, acquired title deeds under Section 21. And that's the time the doctrine of fixture was introduced, the British doctrine of fixture, which is basically the claiming what you have bought and what is permanent on the land belongs to you. So it's land plus the plantation plus the buildings and so forth. So the very first time when the local, the indigenous started enduring the hardship was then. And that problem up to today has not been resolved. Then we come to the what you call the 10-mile strip. The 10-mile strip, as you all know, this is a strip land running for a distance of 10 nautical miles, parallel to the Indian Ocean, commencing at Vunga at the border with Tanzania up to Kipini, including Lamu, Akipengo. And Justice Monyale is one of the, I think he comes from around that region. Yes. So I have also, so now looking at the specifically, Section 7, of course, of the Land Act gives the parameters upon which one can acquire land. That is through acquisition, land adjudication process, which we all know, the compulsory acquisition, settlement, transition, and so forth, which I don't want to spend time on that. But now we go to the crux of the matter and ask two questions. Can a squatter claim a right over property, private property? And of course, the answer is yes, that can be done. And how is that done? That is done through the land adverse possession, which we are all familiar with. And land adverse possession is the enjoyment of real property with a claim of right when that enjoyment is opposed to another person's claim and is continuous, exclusive, hostile, open, and notorious. So that of course, that right is created under the provision of Section 7, 13, and 38 of the Limitation of Land Actions Act, and where the Section 7. So we are saying that as long as the parameters are very well spelled out, and in the case of Mutana Lewa, which Nyange tells me he argued that case authoritatively, has created the parameters on how to enjoy that particular right. That you know that it's about living on land continuously for over a period of 12 years. It has to be continuously. It has to be uninterrupted. However, the what you call Kuloba, yes. Kuloba has, in the case of Gabriel Mbui versus Mukindia versus Muraya 1983, did come up with what I call the 7 pointers. I know that I don't think you have, it's visible. Sorry. Oops. Oops. Yes, in that case, Justice Kuloba, as he then was, has argued that it's just not straight jacket that you are able to, so long as you have lived on land continuously for 12 years uninterruptedly. The other parameters, about 7 of them that he has spelled out. Oops. I might need your assistance. Sorry for this slide that is missing. Oh, okay. are numbered actually. Let's go. Let's bring you the numbers of total. Yeah, so that I'm seeing here the possession by the person seeking to prove title by adverse possession, it has to be visible, open, and notorious, giving reasonable notice. Then there's also to be non-permissive use. You have to prove that you have been using. You've actually been in occupation of that land, that period. Then one that I find rather difficult, even in practice right now, is that the occupier is supposed to demonstrate that he has been having an impression of a title. We've had this discussion even among ourselves as judges. If you look at Order 37, it talks of if you are able to produce an official search of a title, is that sufficient or not? Because now you are already living on a parcel of land. You do not have any legal rights over that land. Where are you expected to get a title to that land so that you are able to prove that you qualify for adverse possession as a squatter? Those are some of the discourse that the jurists are going to continue having, and even for us as judges. So that the answer, and this has not been a big issue because Mutana Lewa has already demonstrated, has given us the parameters, very clear parameters on how to acquire adverse possession. Recently, there was a decision in the Supreme Court. I think you are all familiar with this decision. This is the case of Temas Muka Maulo and Walter Washington Baraza, Nyongesa versus Robert Ouma Oduori, which was a Supreme Court number 16 of 2021. On the 19th of May this year, the Supreme Court was faced with an issue of, again, adverse possession. Of course, one of the advocates the other day came to argue before me. I will not give the name for reasons of, I'm guided by the principle of sub judice. And I almost got shaken because I thought Mutana Lewa had been overturned. But only to read it later on, I found that the case of Thomas is simply the Supreme Court disqualified it on the grounds that it did not certify the ingredients of Article 164.434 of the great national importance. So they did not even discuss the merits of the land adverse possession at all. So having answered the question as to that a squatter is able to acquire rights of a private land, I now move on to whether a squatter is able to acquire rights over public land. Now, this issue was deliberated extensively by the Supreme Court again in the case of to buy, where the applicants did file a suit in the Court of Appeal, arguing that they were being evicted from Wilson Airport on the grounds that the structures that were next to the airport were interfering or were causing security hazard to the crafts, so they had to be moved. So they argued under Article 43 that the state had a right to create a right of housing to them. But the respondents argued that you cannot acquire title or rights over public land. Although the Supreme Court did agree with the respondents, but the only qualification in V2 is that the right of an individual to housing can be created from land that is public land, which means that under Article 43 of the Constitution, the state has a right to, in as much as you remove those people from habiting there, but again, you're also thinking of how do you make them acquire decent, habitable settlements elsewhere. So they automatically acquire the right to housing arising from a public land. And that decision, again, has also been discussed in the case of Moi Educational Center and a few others. So so now how do we assist the squatters so that they are able to acquire their rights like any other person? This discussion has been held extensively in very many reports. The Njonjo report, the Ndongo report, and the Truth and Reconciliation Commission. And one of the recommendations that they were making is, of course, Njonjo did make recommendation just before the promulgation of the Constitution. So most of the recommendations have already been implemented. And one of it that has come out clearly is that the government has a right to acquire land. It can do a need assessment of the land that is not being utilized, the land that is fallow for the absentee landlords, and that land can be set aside and be created through the settlement scheme, and the squatters can be considered. There are also proposals that we can persuade the landowners, the people who already have title deeds, they can be persuaded to sell out their land so that you allow the people who are claiming customary rights over the land to acquire. And that way you are able to settle them. A case in point, you are all familiar with the Waitiki case, which, well, I'm discussing it, although it is before me. But the Waitiki case, for those who do not know the facts, are that it's 1,000 acres. The owner had 1,000 acres just here in Likoni. And the squatters invaded, claiming, of course, their rights as indigenous people. And thinking that it was becoming a security menace, they were not able to be removed, the government had to step in and enter into negotiation with the owner, where he agreed to part with to extinguish his statutory rights under Article 40, and the land was sold to the individuals and subdivided to them. Of course, later on, he has come back to court to file a case that there was a case of trespass by Kenya Power and Lighting by connecting electricity to the people. So, so that, to me, I think the Waitiki case is one case that stands out almost on its own self. Of course, we are also making proposals. I don't know, slide that. Yeah, the example of settlement of of squatters is not something that is only unique in the coast. It already happened in the White Highlands, and the lands were bought and the people were settled there. Of course, as judges and the magistrates who are in the land and environment court, we are trying to create a balance. And again, now I'm saying the legislation can also be of use, because this country has enough legislation. I cannot say that we need to legislate more on that area. But the challenge, the biggest challenge we are going to have, and I'm sure that will come in the panel, in the plenary discussion, is that to balance between proprietary rights, somebody who has presented a title deed under Article 40 and is claiming that he has, of course, he has a title, is Section 24 of the Registration of Land Act 24 and 25. But again, he has found people living on that land overriding interests under Section 28 of the Land Act. How do you now create a balance? How do you tell the difference? How does the customary law comes in? Of course, Justice Sila Mnyao and myself, we seem to be disagreeing on that point, where Mnyao says, history, all of us have suffered historical injustice. Name any community in this country that has not gone through historically. We have suffered. So the law does not, tell me in law, where does that? So the only way, I think the only solution, and this one again, we have myriad of decisions, is to interrogate what we call the root of the title, to find exactly how did this proprietor acquire title deed? Is it right from the time of the Land Ordinance Act up to now? Did he acquire it lawfully? Did he follow the due process? If it's for example, land, individual land, did he pass through the normal processes of the Land Control Act board? Did he appear before did he pay stamp duty? Did he pay the statutory fees and so forth? You interrogate that until you are satisfied that yes, this title is good and therefore is prima facie evidence conclusive. When it comes to, of course, public land, you're also you're interrogating and saying an alienable, public land is not alienable unless you have a letter of allotment. That letter of allotment has gone through the due process of the RIM up to the time the grant has been given by the commissioner, it's brought back, and a title deed is created. So those are some of the things, they are factual. These are really, and that's why we insist on having hearings, so that we are able to interrogate all that. Now, the other challenge we have is, of course, when you are faced with the 3 or 4, 5 owners of the same land, and each one of them has a title deed. How do you respond to that? How do you justify that? Food for thought. I leave it to you. Okay, so in conclusion, I just want to cut short the process. My conclusion is that the squatters, they still have hope. They have hope in the sense that we need to create awareness to them. And that is when I say we, I'm talking about yourself, MLS, and other stakeholders. The government needs to intensify the enforcement and the implementation of the already existing useful legislation and policies. There is also need to implement the very many reports that have already been prepared on this subject. We have in particular the 1976 Parliamentary Select Committee on Coastal Problems, and that particular committee addressed the issue of the Land Title Ordinance and Land Titles Act, which I said generated all the problems that we are facing today. And of course, the Commission, Njonjo Commission and the Ndongo Commission, the Truth and Reconciliation Commission. So I think I would like to stop there, and then I leave the others to question time. Thank you very much.
Thank you, Judge. I just realized that we did the clap. What did we agree on? Yes, no noise pollution. Now, I know most of us have many questions for the judge, but I'll ask you just to hold on, just write your questions down. Then we'll have a panel discussion. Remember, the judge has mentioned earlier that he would wish to have a discussion with all of us. So we'll have a panel discussion. We'll be able to ask the question not only to Justice Naikuni, but to the other honorable judicial officers. Justice Naikuni, on a light note, you've given us a food for thought. I'd also want to give you one. When I was introducing you, I mentioned Justice Naikuni, and I've just been saying Justice Naikuni. But Justice Naikuni's full names, Honorable Lucas Leperez Naikuni. Ivy Chelimo was recognized recently by our Deputy President. And I want to challenge you and also give you a food for thought. Your name has two L's. Think about L squared Naikuni. Then do as our deputy did. Who has given you that name? Now, let me introduce Makuto. Makuto us through the next session.
Thank you very much. I think for those of us that practice before Justice Naikuni, he has given you leakage of the submissions you should make before him. Uh, I think we will have more robust discussions and court proceedings before that court. And just a request to the judge to forward the presentation to MLS. I am sure we will copy and paste and edit and give back to you as submissions. Now, allow me, with a lot of humility, introduce one distinguished gentleman to us. That is Justice Michael Ngolo Mwanyale. Justice Michael Ngolo Mwanyale was appointed as judge to the Environment and Land Court on 4th of July 2021 after an open and competitive recruitment process. Prior to his appointment, he practiced under the style and name of M.N. Mwanyale and Advocates. He obtained his law degree, Bachelor's of Law degree from the University of Nairobi, a postgraduate diploma from the Kenya School of Law, and was admitted to the role of advocates on the 26th of April 2007. He initially practiced at law at J.M. Macau Advocates, Nyachoti and Company Advocates, Mturi Kamande Advocates, Macharia Mwangi and Jeru Advocates before setting up his practice in 2013. He served as a board member, St. Thomas Girls School, St. Patrick's Academy, as well as Pwani Vocational School for the Deaf, all in Kilifi County, and currently serves as the ELC judge in Nandi, that is in Kapsabet, where he is the chair of the Nandi County CUC and doubles up also as the ELC CUC chair. Now, I have had chance to practice in Nandi County, and I was just pulling his leg and telling him next time he comes, maybe he should come with a real tea. I think in Mombasa we drink adulterated tea, and he will have something to say about that. I will welcome him to make a presentation on the judicial attitude towards Environmental Commission. We can do showers as we welcome him to make that presentation. Karibu.
Thank you, Mr. Makuto, for the elaborate introduction. my Lord Justice Naikuni, Honorable Mburu, Honorable Kiage, Mr. Opulu, Chair MLS, all members present, good afternoon. So as a practitioner, I used to handle certificates of urgency, and as a judge, I've also handled certificate of urgency, but this was the most, of all those ones I've handled, this was the most difficult because I was only called on Tuesday and was told to prepare for our presentation for today. So I use the skills as a practitioner as well as a judge, and you'll see the presentation whether itatosha mboga. Now, I've been asked to make a presentation on access to justice in the Environmental and Land Court, as well as the judicial attitude to land and environmental litigation. However, my presentation on the judicial attitude will only relate to environmental litigation and not land and environmental litigation. As you're all aware, the access to justice is a key component of the rule of law. It is enshrined in Article 48 of the Constitution of Kenya. So in order to ensure justice to all people, the Constitution of Kenya mooted the 2010 and Article 162B made provision for the establishment of the Environment and Land Court. So the Environment and Land Act was thereafter passed in 2011, and Section 4 of that Act establishes the court. There are currently 37 environmental and land courts spread across the country, and 53 judges serve in the said court. I wish to single out Narok, where there are 2 ELC courts. One sits in Narok town, and the other one sits at Kilgoris. That is because Narok is very huge and vast and had many issues, many land issues, and that's why there are 2 courts that are there. In addition, there are magistrates who have been who are granted jurisdiction to hear and determine environmental and land matters. The said magistrate were granted jurisdiction when a matter was filed, and I think as practitioners in Mombasa, you'll recall the Law Society of Kenya versus Malindi Law Society, which from the decision of that court, it was said that the magistrates could now hear land and environmental matters. So Justice Chief Justice Emeritus Maraga appointed 81 magistrates initially to hear the matters, but there was a recent gazettement by the current Chief Justice, so that as we speak, I think there is an ELC court under the magistrates courts in all sub-counties in the country. So there is enough access to justice by every litigant in the country, because in every court in the country, there's at least an ELC magistrate who hears matters. That is one aspect. You are also aware that the National Environmental Tribunal is also available and as established by law to hear and determine disputes relating to the environment. We had earlier on today Mr. Balala making a presentation. So there is still now access to justice through the National Environmental and the National Environmental Tribunal. The rent restriction and the business premises tribunals are also tribunals under the ELC, which serve as first port of call for landlords and tenants who have disputes, and that has broadened the access to justice to members of the public, because they serve rotationally, and members of the public are able to file their suits there as a first port of call. Let me highlight paragraph 28K of the practice direction granted in Gazette Notice number 5171 of 2014. That particular paragraph provides that the court can issue orders of status quo. Now, when you have an application for an injunction and you know how the applications for injunctions usually take time. The best and proper way for you to get that injunction is to apply through paragraph 28K of the practice direction, so that you're able to get the status quo orders. And this has been upheld by the Court of Appeal in Muga versus Kunga. And recently I made a decision similar in Gilbert Kipruto Menjo versus Job Kiplimo. So that the more Kenya here is that don't file, I want an injunction, say you want status quo orders. That way you get your injunction, but under the disguise of status quo orders, because those ones are issued very fast and as a matter of course. So practice, that is practice direction pursuant to this practice direction pursuant to the legal notice 5178 of 2014, and it is paragraph 28K that is which allows. So let me now go to the judicial attitude to the environmental litigation. For those of you who undertook environmental law in the university, you are aware with the Rio Declaration on Environment and Development that was made in 2000. That declaration gave some principles, 4 principles, and I'd want to, through this presentation, to tell you how our courts have interpreted those principles of with regard to the environment. The first principle is the sustainable development. The other one is the precautionary principle, the polluter pays principle, and the prevention prevention principle. There was a case called Friends of Lake Turkana Trust versus the Attorney General. It is the first case in Kenya which upheld the principle of sustainability. In that case, the petitioner sought orders for mandamus, compelling the government and Kenya Power to make full and complete disclosures of all agreements that they had entered into with regard to with the government of Ethiopia and parastatal, with the proposed purchase of 500 megawatts Gibe 3, yeah, including the memorandum of understanding that had been signed. So the court in that case, that is Honorable Justice Pauline Nyamoya, as a High Court judge then, before the establishment of ELC, indicated that the principle of sustainable development was applicable in Kenya. She further gave the orders and said that the socio-economic rights of the people living around Lake Turkana ought to be protected under the principle of sustainable development. It's a very interesting case, and it forms the first and foremost judicial attitude towards the environment, on the environment with regard to the Rio principles. On the precautionary principle, the famous case of Kenya Association of Manufacturers, I think you all know this case. This is the case that stopped the usage of plastic papers. So in that case, a dispute arose as a result of the decision by the Cabinet Secretary to ban the use and manufacture and importation of certain type of plastic bags for commercial use. So the court applied the precautionary principle in this case and declined to grant the conservatory orders, because the orders were to stop now the implementation of the ban by the minister. And it held that even though there's no evidence of whether the plastic bags used to harm the environment, the precautionary principle ought to have been applied in the matter. Another decision that has also upheld the precautionary principle is Isaiah Luyara Odando and another versus NEMA. These were officials of Ufanisi Center in Korogocho, and they filed a petition seeking conservatory orders to compel respondents to shut down polluters and force industries. And the court in that case also allowed the petition and found that the respondents to have polluted and caused harm to Nairobi and Athi River and there were damages of 10,000 that were granted to the petitioners in that matter. Under the polluter pays, there was a case that was argued in Mombasa. I don't know whether Kituo cha Sheria was involved. The Owino Uhuru village in Changamwe, I think it's a case that most people know. So that case still emphasized that a polluter of the environment ought to pay. It was a decision by Justice Amolo done here in Mombasa, and I think most of you are aware of it. In the prevention principle, as part of the principles that were developed in Rio, there was a case filed before the Environmental and Land Court in Malindi, Amina Said Abdallah and two others versus the county government of Kilifi. So in that case, there was an issue of dumping and continuous of dumping of solid waste, another form of waste on the plaintiff's suit property, just like there was dumping in around the VOK area. So the court held that it had the jurisdiction to issue under the principle of prevention to order that because it says that it was less costly to allow prevention than to allow environmental damage, and it used the prevention principle that is part of the those are part of the Rio declaration. So in summary, we are saying that the courts in Kenya have upheld the Rio principles as cited in the above decision. There's also a decision by NET, the Environmental Tribunal, the National Environmental Tribunal, in the Lamu call case. It was called Save Lamu, where they cancelled the environmental impact assessment report that had been done, and in arriving at that decision, they also used the principle of the precautionary principle, that you do not need to have evidence of environmental degradation to make a decision. So the attitude of the judiciary towards the environmental matters is that they do, and as demonstrated, is that we have, as a judiciary, enforced the Rio Declaration on the environment. So that when you now approach court, those are the principles that you need to highlight in your case: the polluter pays, the prevention principle, and the sustainable development principle. That will be the end of my presentation.
Thank you very much. As I just wanted to get assistance so that we can prepare for the plenary session. I think, Judge, you can take a seat for a moment. We just have a few minutes, then we have a plenary session. We would want to
Good afternoon. May I request our honorable judicial officers to just come in front, have a seat. You were already introduced to our two good judges, but you're here to be introduced to our honorable magistrate. So allow me to introduce Honorable Kiake. Honorable Kiage is a senior resident magistrate at Mombasa Law Courts. He joined the judiciary in 2013. Before then, he had worked as a state counsel at the Office of the Attorney General. He holds a Bachelor of Arts in Economics and a Bachelor of Law degree from Karnataka University in India. Honorable Kiago is a firm believer in justice and the rule of law and passionate proponent of the constitutional ideal of access to justice for all. A promoter and champion of public education and social change through legal knowledge and an avid participant in legal education outreach programs. He's one of the magistrates here in Mombasa that handle environment and land issues. Karibu sana, Honorable Kiage. And just before I hand over the mic to one of my colleagues to introduce our next magistrate, maybe I'll just have a question for you, Honorable Kiage. What has been your experience in terms of handling environment and land matters at the magistrate courts?
Thank you. Good afternoon, everyone, and thank you very much for the welcome. What has been my experience in handling land and environment matters? I want to say that the area of land and environment matters is quite a vibrant area of law, more especially here in the coast region and Mombasa in particular. We have quite a number of matters that do come to us which are very unique in their nature. I don't think that there is any other court in the Republic, I might be wrong, which gets to handle areas of law such as house without land, just as Judge was talking about. And when you are faced with a case that deals with an issue that is not very clearly legislated upon, then the only recourse is to case law. And so I'd say Mombasa is quite unique in the kinds of matters that do come before the courts. The other thing that I will say is that the litigation on land matters here in the coast region is also quite vibrant. We have very many litigants. We have the category of individuals that Judge was talking about, but I would also want to say that we have genuine squatters as well as professional squatters, in my view, and sometimes how to draw the line and to distinguish becomes a tricky affair. But I think that with the help and assistance from both the bar and the bench, we are able to mitigate these issues, and at the end of the day, serve justice to the mwananchi who comes before the courts. So to sum it up, I would say that my experience has been quite an enriching one as a land court, and as magistrates, we handle a wide array of issues. But I think specifically on land and environment matters, it has been a very enriching one, and I'm very thankful that we have decisions that guide us from the courts above that we refer to whenever we have to make these decisions. Thank you. I hope I've done my assignment.
Thank you. Thank you. I have the pleasure and honor to introduce Honorable David Wanjohi Mburu. Honorable Mburu is the Senior Principal Magistrate presiding in Mombasa. He joined the judiciary on the 1st of July. It's very clear here, you can remember, 1st of July 2008. How many years are those now? From then to now. Lawyers are poor mathematicians. He's worked in Garissa, he's worked in Meru, and I can confirm when he was coming to Mombasa, he was coming from Milimani Commercial Court, and I had the privilege to have insider information that Honorable Mburu is a workaholic. He will deliver judgments and rulings on time, and those who have had a chance to appear before him, it is in very rare instances that you would find the judgment or the ruling is not ready. And he's always eager to proceed. In fact, if you listen to him, he says, we have too many mentions now. Why don't we fix this matter for hearing? Why do we keep mentioning matters for pre-trial or for you to have agreed whether you are consenting or not? So there is no need of having a very long list of mentions. Let's fix this matter for hearing. You can see he has the urgency and the energy and the need to quickly dispense justice. And that is his philosophy as far as I can tell. So I am allowed one question to Honorable Mburu. You've been in Mombasa for some time now. And the question is, in your experience, you can compare, you can do a comparison of your experiences maybe in Garissa, in Meru, and now that you're in Mombasa. What is the experience like sitting there and litigating, hearing cases on land and environment? Maybe within 5 minutes you can give us your experience so far in Mombasa. Karibu.
Thank you, Mr. Nyange. I must first have the kind of words that you. Yes, thank you. I must first appreciate those kind words that you have used to describe me. And on the question of my experience here, I must say that this is totally different for me because as my brother Honorable Kiage has spoken about the I don't know if you call it a doctrine or principle of house without land. That was one of the new terms I learned when I came here. I've been here for just a few months, although for sure I've not concluded any matter in land, but I'm handling quite a number. So that, of course, amazed me because I had never heard of such a thing before, and I'm still learning about it. But generally about the manner in which cases are being handled here or litigated, I think there's also not so much of a difference from where I have worked before. And maybe my observation is that there's a general trend, both here and in other places I worked, that most land matters, when they come to court the first day, are very urgent. And almost, I can say 90% of land cases come under certificate of urgency. And how the court handles the matter on the first instance then determines
what will happen afterwards. And what I have noted is that if the court grants interim orders, then of course the plaintiff will not be in a hurry to prosecute the suit, but the defendant of course will be very keen to have the matter proceed or have the orders discharged. On the other hand, if the matter is not certified urgent and maybe orders are not granted, then the urgency also dies and the matter might not even be fixed for pre-trial or for hearing. So like for the last 2-3 months, part of the many mentions I have and maybe my colleagues for matters which are dormant, either because orders were given and then parties became comfortable and did not fix the matter for hearing, or because on the first day, no order was given, matter was not certified. And so the plaintiff lost interest. So like yesterday, I had a mention, I think of mentions of around 50 matters, and about 30 of them should have been ELC. There are matters that we have retrieved from the registry of our own motion. We are just trying to revive them because from the first day they were filed and no orders were given, then the plaintiffs disappeared. So we've sent notices, we have been mentioning them, and nobody appears. And of course, you know what will happen after some time. Most of them might end up being dismissed for want of prosecution. So my experience is that with land matters, the urgency dies after the first appearance in court. And it's not in many cases that you find people willing to proceed with the main suit. But applications appear to be the most fashionable thing and the most fashionable style of prosecuting those matters. So I think that sums up my experience, not just about Mombasa, but generally where I've worked. Thank you.
Maybe the showers. Now, allow me open the plenary session. We have had presentations from Justice Naikuni, Justice Monyale. We have heard from Honorable Kiage and Honorable Mburu. And I'm sure quite a bit of questions have arisen or wamechochea maswali. And you would allow me, the plenary will allow me, open up the floor for questions. We will take a round of questions and then we will allow them answer. The questions, just hands up.
Good morning, panel. Good morning, members. Sorry, apologies, and sorry for contempt of. My name is Daniel Maina. My name is Daniel Maina. I'm here on behalf of Kisiwani Conservation Network. Well, Daniel Maina again from Kisiwani Conservation Network. So I've loved the presentation, and regarding the squatter issue, I'm not a lawyer, but I'll benefit from an answer. I'm concerned about the creation of squatters by the Constitution itself. And perhaps you'd help me understand it better. There's a section on definition of public land in the Constitution. And one of the definition regards mineral resources. So it says all mineral resources are public land. So what happens because the discovery has not yet been done, but after some time we undertake exploration and we discover perhaps beneath this building there are huge reserves of oil or heavy sands. So happens does it automatically become public land? Because minerals will have come first. I mean, what is the process of distinguishing between our existence now as a hotel, as a land?
I think I'm audible. I'm audible.
The second issue, we have just talked about the challenges of uh, matters of land come to you as urgent as possible, but within the first day they are gone. And I think we have a big concern with the issue of the defending or protecting environmental defenders. Because some of the environmental issues that are coming to court are coming from individuals who are against, huge corporations, some who are not very ethical. And sometimes during or after the, appearance in court, we have new challenges of even threats to life. And perhaps it's not their wish that the second day going forward they don't come to the court anymore. Perhaps it's an issue about protecting those defenders of environmental law. And finally, I have an issue with the international, perhaps I would call them bilateral agreements on trade. So the bilateral agreements are the ones that create export-import opportunities. And when we buy goods, perhaps goods that contain chemicals that affect the environment, are usually negotiated in a very political way. And by the time we discover that they've created a route for pollutants or things that harm the environment to come to our country, usually that happens much later after the opportunities has been created, and it's impossible now to stop the traffic. So I would want to know whether it's possible to have the environment court represented during those negotiations so that we can undertake the environmental impacts instead of becoming reactive. We are talking about plastic pollution. Plastic pollution will continue because petrochemical companies are very powerful and they enter into trade agreements with Kenya, either through these bilateral agreements or multilateral agreements, because Kenya is now part of the African trade, free trade area, the East African free trade area, and some of them are not aware about the impact those products or opening up the markets will have on the environment. It is my wish that they would have the court represented or links to the court represented during those negotiations. Thank you so much. Thank you for the attention.
I have answers to those 4 questions first before we take the next set of questions.
Maybe before I go to Mina's question, I just wanted to make Chair, you allow me to just to make a very few comments on the general attitude of the courts. We just, in addition to what Honorable Mburu has indicated, Environmental Court has noted cases of multiplicity of cases filed in the High Court and the lower court over the same subject matter. And we are trying to discourage that through consolidation of matters, because the subject matter is one and the parties are the same. We also have, and I'm glad I was not able to mention that, professional squatters. That is very true. We have people and we already know them. You see them appearing in many, many matters. They're the ones, they are specialized in getting to know which lands they can invade, quote unquote, so that they are justified as squatters. So professional squatters are there. There is also the comment of there is a negative attitude. I don't know whether it's negative, but the lethargy. We are not seeing environmental cases being filed as many as when this one. I'm going to tie it very closely to what Maina has said. 90% of the cases we're handling are land matters. We do not have, apart from the Owino's case, and now I'm doing the Mwakirunge case of dumping solid materials. We are not seeing a lot of cases coming forward, and we are raising concerns. Now, going to the question asked by Minor, he started by saying that the Constitution has created squatters. I got a bit I got a bit scared because I haven't seen that. But when we went straight to definition of public land, the categorization of land, private, public, and in community, I am safe. Yes, it's true. All minerals are under public, because land is what is on the surface and what is underneath. And you know that 6 feet, after 6 feet, is common knowledge. That is public land, and that's where you are buried up to 6 feet, Mr. Minor. So anything that goes beyond that, and that is in, universal, is land that belongs to the government. As far as the mineral is concerned, is a very emotive issue, and is also very common in the coastal region, particularly the Voi, Taita Taveta region. And the Mining Act, Cap 409, I guess, makes very clear provisions on extraction. You enter into a contractual, you get consent, you get a license through the ministry. Now we have a new ministry of blue economy, and I think something by Mvuya is also. So you are not denied. The community is not denied to extract mineral, only that it has to do it in a more structured manner. But it's an area, of course, I'm totally in agreement with you that the community has been exploited, and through that we have also seen degradation of environment in the course of the mining. So we are not defensive, and I'm saying is one of the things I said in my recommendation, we need to enforce. The policies are there, but they need to be enforced and implemented. So mining is one area that we need to do that. I totally agree with you. Maybe I don't know whether I'm going to be eating Mwanyale's lunch, but we can share a plate. We are on the point that the environmental court should participate in contractual enactment. Perhaps you may need to understand the jurisdiction of the court by reading Article 162B of the Constitution, and also together with Section 313 of the Environment Land Act, together with Article 150 of the Land Act and 101 of the Land Registration Act. It specifically specifies the jurisdiction of the court. The court is only an interpreter of the Constitution, and it cannot be seen to be doing policy matters, to appear in conferences, to negotiate. That is now Mr. Makuto's plate of food. That is a more an executive role. So you remember that we have separation of power, judiciary, executive, and the legislature. So Mr. Minor, you will put us in trouble. You'll be told that now we have acted ultra vires. We have acted beyond the powers that is given to us by law. That is a much I can say as far as that. But I'm happy that you are seeing that we can do it. If they are unable to do it, we'll step there and do it. But we have our job to do. Our job is well cut out. I think, maybe Judge, you can add something. I don't know.
Thank you, Judge. Just in addition to what Judge Naikuna said, in response to Mr. Minor's request that the court does the negotiation, I think there is a ministry of the one dealing with the natural resources, and also NEMA, because NEMA is the authority that is empowered under law to manage the environment. So maybe you should take your concerns to them, that they be involved in the negotiations. The court would not have any role to do in negotiations. I think we've answered the three questions.
Maybe I noted Mr. Masore also had a question.
Hello, everybody. My question is with regards to the issue on the court attitude. and I'd like to pose this question to the Honorable Judicial Officer before us. It is said time without number that jurisdiction is everything, and without it a court can do no more. I like the way Justice Nzei says that out of nothing flows nothing. The Supreme Court is instructive in the case of, I think, Karisa Chengo, that demarcates the various roles of the specialized courts vis-a-vis the role of the traditional high court. I use the word traditional high court for with all due respect. Now, I talk about jurisdiction with regards to transfer of cases between these specialized courts and the high court and vice versa. I think Justice Joel Ngugi, as he then was, says that specialized courts have something that is called incidental concurrent jurisdiction, in that a specialized court has jurisdiction where it feels like, for example, the land court feels like, okay, this land question is with regards to a charge. A bank wants to realize its security, and as such, it doesn't squarely fall within my jurisdiction. As instead of dismissing it with cause for want of jurisdiction, or rather striking out, it refers the same to the traditional high court. The same thing the judge says about the high court. When the high court feels like, for example, this issue is, let's say, matrimonial property, and the only property in question is land, let me not touch on it, let me refer it to my brothers at the ELC court. That is what Justice Joel Ngugi, as he then also says, under the doctrine of incidental concurrent jurisdiction. But then we still get emerging jurisprudence, for example, by Justice Korir, who says that, look, you guys, as the program rightfully indicates, we've had the Environment Court for 10 years. You guys have had enough chances to play trial and error. If you file a case in the wrong jurisdiction, then the court, and I think there is the Phoenix Assurance insurance cases where the court says that if I don't have jurisdiction, clearly I also don't have jurisdiction to transfer a case to a court that has jurisdiction. Because as Justice Nzei says, out of nothing flows nothing. Now, I will ask the honorable judges, what is your attitude? Will you readily dismiss a matter simply because it is filed in the wrong jurisdiction, as Justice Weldon Korir says? Or you, in the other hand, go the route of Justice Joel Ngugi, who says that you have incidental concurrent jurisdiction to transfer to the right court? And what parameters will you be using? That is the issue with jurisdiction on the transfer. Then my other question is with regards to a magistrate's court. I'm happy that we have magistrate courts who here who deal with land cases. They are called special magistrates under Gazette Notice 6024 with regards to dealing with employment and labor relations court cases. But with regards to land cases, let us say that a magistrate, as rightfully said by the Honorable Magistrate Kiage, they wear various hats. Unlike a specialized court judge who only wears court of the hat of jurisdiction of environmental cases, a magistrate wears the hat of he can listen to land cases, he can listen to employment cases, and he can listen to commercial cases. The only thing that will distinguish what hat the magistrate is wearing is the titling of the case. For example, if I'm filing a land case at the magistrate's court, I will file it as Magistrate Course ELC number. If it's an employment court, magistrate court ELRC number. So, is a litigant, just as the litigant has the right to file a preliminary objection if a case he thinks has been wrongly filed in the ELC, and says that, look, this case ought to be interrogated by the traditional high court. Does the litigant have the same right before the magistrate court and says that, look, this litigant is invoking the magistrate court to wear the wrong hat? So that now I feel that this is a pretty much land and environment case, but it is being filed as a ordinary commercial case. So that now I raise appeal within that very same MCC case, Magistrates Commercial Civil case, saying that the court has been wrongly moved as a commercial case, as opposed to the court being moved as a land case. That is my question now with regards to the issue of jurisdiction and the magistrate. And then finally, Justice Naikuni talked about the issue of squatters, and you even went ahead and gracefully offered some kind of recommendation. My question is this: don't you think that a good solution to rather mitigate the chances of having the squatter issue balloon, as your article rightfully said, that if it is not settled sooner rather than later, it might explode, just as it is a taking time? Don't you think that is now high time for Parliament to pass the law that I think at Article 28 of the Constitution talks about minimum and maximum holding of private land. Don't you think it is the right time for you, even through your judgments, honorable judges, to make such declarations? Because I say this with tremendous respect on the doctrine of separation of powers. You notice that the case of Sayuma, the court's judgment was actually extrapolated and put on statute word for word, so that it means that Parliament in some instances would actually go to court proceedings, get the judgment, and lift verbatim the recommendations that are given by judges, even in obiter. So in this particular instance, can the Honorable ELC Court, because you are the only ones with jurisdiction to do this thing, can you make a stand, can I call it a stand, demand to Parliament to forthwith incorporate, rather enact an act of Parliament that will pretty much ensure that the issue of minimum and maximum acreage is legislated, so that we have minimum cases of squatters? Thank you very much.
Maybe we can take one question.
Good afternoon. I hope I'll be audible enough. I am Busco Juma, an environmentalist, environmental human rights defender, and also director of a conservation organization known as Big Sheep. And my first question goes to, I'll start by saying that in 2018, Mombasa was almost removed as an island by the UNESCO. It was being deleted as an island because of the encroachment that were happening at Makupa Causeway. And this was one of the cases that we did follow much because a lot was happening back in 2018. There were the companies that were busy doing the land reclamation, and then there was the Kibarani, the famous Kibarani, whereby there was the seaward dumping of waste. And it is on these matters that I wanted to pose my question. And one is because during the encroachment, whereby there are some companies that were doing the encroachment, we followed up on that issue, and one of the things that we did was to petition the National Assembly in regard to the same. And what followed up after that was His Excellency, the President, the former President Uhuru, tasked the National Land Commission to come and hear the case here at the Mombasa regarding the grabbing of land at Kibarani, and I appeared on the National Land Commission in regards to the same. And since then, nothing had been done on that. And that leads me to my second question in regards to the Kibarani dam site issue. On the same, on 22nd of June 2018, NEMA issued a restoration order demanding cessation of seaward dumping of waste at former Kibarani dam site and removal of the waste from Kibarani dumping. And then the matter was taken to High Court, and the Mombasa County government then applied for judicial review at the High Court of Mombasa, seeking a cessationary order, quashing the restoration order and affirmation criminal proceedings. What followed then is the court extended the order, whereby Francis Toya then, who was acting on behalf of the county government, the court has instructed the case to be taken to the ELC on conservatory basis. And this brings me to my questions on those two cases of Kibarani encroachment and the dumping of waste at Kibarani. What really happened thereafter, because the NEMA had sued the county government regards to the same, and we wanted to be added as an interested party in the case, for which that didn't happen. But what followed in that issue was that the case didn't proceed, and it was NEMA asked the case first. The county government, what said was that the case was directed to the wrong office, because he was the secretary of the county government, yet he said the case was to have been taken to the CEC of Environment then. Also, in matters of jurisdiction, just in follow-up to my former presenter here, it was in regards to jurisdiction. And this I want to combine with my first statement regarding the NLC issue. And in this case is that the case was on High Court, and then it was seen that this matter should have been dealt with, at the ELC courts. And then an NLC issue whereby it was the NLC was acting as a High Court then. Those two issues, none of them saw the day of light. And if you are familiar with Kibarani now, most of the processes that were going, what we were trying to seek then, everything came to conclusion. Those who are extending their properties did the same, unabated, and as much as the president asked the NLC to come and sit in Mombasa for the same case. Two, the Kibarani encroachment happened, and we're just talking about plastic pollution. It was sad that that matter, we were not able to be added as interested party. And also apart from that, the stopping of dumping didn't happen. I know Makirunge is going to be the same kind of case, and I hope that now that it is within your able office, you're going to act differently. So mine is on jurisdiction on how those three, because we act as environmental defenders, but not lawyers. So when we're being pushed from one jurisdiction to the other with the cases, I think it really leaves us on a ping pong kind of game. So I wanted to bring those two issues and to see how then can it be addressed and how do we deal with those matters now that you're on 10 years of our CUC and that the ELC court is also active. Thank you.
May I would request when you ask the question, make it short, precise and to the point. Madam Wambi had a question. You allow us to take this one and then we come to the plenary.
Yes, I have two questions from our online participants. Ms. Teresia Memia asked a question to Justice Naikuni. Are there any governing laws on house without land? Then our patron, Ms. Njau, also to Justice Naikuni. We have cases where one ministry, for example, the agriculture, claiming ownership of a public land and government-owned property. Can the court exercise its mandate of ADR when such disputes arise to compel parties to resolve such disputes through roundtable negotiations?
Those four questions put together, if my mathematics serves me right, I'm not opaque, Mr. Nyange. Oh, sorry, advocate. You've asked a question that is actually in the heart of the ELC as we speak right now. We are having a tussle with the Court of Appeal back and forth. And basically is on the issue of jurisdiction. And I'm happy you've quoted Justice Nyarangi, as he said was from the Lillian S vessel, that jurisdiction stops is everything. And once it's your jurisdiction is mentioned, you down your tool. I agree. Where I don't agree, and I want to agree with Justice Mumbi, as she then was the incidental concurrence, is that we have been caught up with the now famous case again. Mombasa and Malindi seems to be the main case of Peter Kangede versus Cooperative Bank. I don't know whether you're familiar with that case, which I have read it. I read and I reread, and I still don't understand exactly what the good judges meant. Because they did indicate that so long as a matter has a commercial component in it, then you cease to act. You down your tool. My understanding is that if a matter exceedingly gets to accounting, mathematical issues, then you have to down your tool. But so long as a matter raises issues pertaining to land, as stated out under Section 3 and 13 of the Environment Land Act, I will deal. And I have done that right now as we speak, a matter that was before Commercial Court, Justice Joachim Mwangi, and another matter brought again before my court, but it's exclusively on the ownership of the land. What do? Do I stay the proceedings and I wait for until High Court makes a decision on matters of shares from a company which is property on the land? Or do I proceed on to adjudicate on exclusively on the use, ownership, and occupation of that particular land? Those are the questions. And what we are saying is that we are insisting that we'll proceed on. We'll proceed on as far as our purview goes. Then we down our tool when it comes to now commercial, strictly speaking, accounting, those other issues, as guided by that is the Peter Kangere. Now, when it comes to the transfer, and that is the Phoenix case, Phoenix has also now created more confusion because once you realize you don't have jurisdiction, you stop and you don't have the power to transfer either to the other court. What are you doing to a litigant who has even caught up by limitation period? You are causing more access to justice, you are causing more sufferings. Again, an argument has been brought before me, a matter that the land falls within Kilifi area. And an appeal was raised and said that this court in Mombasa cannot deal because it's a matter in Kilifi. And I quickly went to section 12 of the Civil Procedure Act, which talks of the local limit where the land is situated. Lucky enough, the parties, the defendant resides in Mombasa. So you look for avenues to hold on into a matter until it is purely exhausted, because Phoenix is actually creating an injustice. And I'm very soon, I hope you lawyers will move to court on its constitutionality. Now, coming closer to now, and this is now the elephant in the room, the Kibo case, Benjamin versus the Kibo distillers. And I missed Mr. Balala's presentation because I was very eager to hear, because Kibo has actually is destroying the environment and land court. A petition has been filed. It's raising all matters of issues under Article 70 of the Constitution and the infringement and the violation of the rights of an individual as far as the environment and land is concerned. But I'm told, stop it. If it matters to deal with environment, take it to environment National Environment Tribunal. But my argument is this: the National Environment Tribunal, with all due respect, confines itself on the issuance of license. So I will let them do that. That one I'm not deal with the license, and I've taken so many matters there. But I give them limitation. Within a particular period, you will have finished, because I want to continue with these other aspects of the violation of the fundamental rights pertaining to environment. That is the main distinction. So that is as far as I'll ask my colleague also to spend time on that, because it's a very academic area. Now, the creation of limits, land limit. In my paper, actually, it's just that I was rushing through. It makes that suggestion that a land that is not developed, is not occupied. I said take stock. The government will take stock, and we shall do it, because the Njonjo report, we are allowed as judges to use reports, policies that are available when we are writing our judgments. We shall be very soon be making judgments. That's how we create jurisprudence on land that is already excessive and underutilized, underdeveloped. You create a limit. Let there be a limit so that we can accommodate, because it's pressure of population. And where do you take all these people? So that is, I think it's more of a proposal than it's a suggestion, and I concur with you. Finally, the last two questions from through Lillian Wambi, Senior Counsel, whether there's governing laws on housing bila shamba. I said, I was very clear, we do not have any law. This is a new area of jurisprudence. Justice Ouko has made an effort to look at it, Faumu case in Malindi, and many others. And I've only said that the only little aspect of it is section 1, section 3, 8 and 106 of the Transfer of Land Act, unregisterable or land without leases. That's basically it, because the problem begins when you issue notice, then they tell you, okay, take your land, but leave my house. That's Abunuasi thing, that kind of thing. So there's no law. ADR anytime. Those who have come to my court, you see how I glow when you when you tell me you are going ADR, Article 159(2)(c) of the Constitution. We'll do it anytime. In fact, if you came in the morning and you tell me the whole cost list is about ADR, we close shop. I'm happy. So, council, that is allowable as far as the public land is concerned. That's the answer I have. Njao, Madam Njao, that is. Okay. I think I'll ask Mwanyale to spend time on the incidental jurisdiction.
Thank you, Judge. The Peter Kangete case, as has been explained, caused more problems because, you see, a lease is registered on land. A charge is also registered on land. When you're registering a charge, you register it on the provision of Land Registration Act. So basically, the charge ought to be dealt with in the Environment and Land case because it's an incidental. However, the Peter Kangete case, being a court of appeal, said charges ought to be dealt with by the High Court. And you see, there's no commercial aspect on a validity of the charge. Was a statutory notice issued according to the Land Registration Act? Because this would be purely a matter that ought to be go to the Environmental and Land Act, because you are looking at the provisions of the Land Registration Act as opposed to the mathematics in the commercial. However, now that the Court of Appeal made that and we are bound by it, there's that confusion as to what would be the cut point. Is this purely a commercial matter or is this purely a land matter? But I've taken the position myself that when it is the validity of the charge, was there spousal consent as required? Was there all those ones? Then those ones I would have jurisdiction. But when it comes to the arithmetic as to the payments, then the commercial court would have. In my experience in Kapsabet, I've come across generational trusts and woman to woman, the traditional woman to woman marriage, not this new notion that is there, where Agogo is a grandmother who did not bear children, gets to marry another lady for her to bear children. And the issues that come to our court is, would those children be regarded as the children of the husband of this lady, for them to be able to benefit from the land? So see, there comes in a bit of succession. And if you see that is a succession issue in relation to the land, it will go to the succession court and then you come and deal with. So that's how we do. We would refer matters where we see that they're interrelated. If it's a succession issue, let it go there, then it comes back. But if it's a succession issue where the property that was taken to succession did not actually belong to these people, it was fraudulent, then it will still come back to our court and we'll decide on the legality of that. On the issue of minimum and maximum acreage, I think, and I'm happy that we have people from the Kenya National Human Rights Commission, it should come in as a public interest litigation from litigants to the court that, look, this provision of the law has not been effected. We want it effected. Kenya National Human Rights Commission or the civil society organization, then thereafter would be able as a court to make a decision, and which will inform maybe now the legislation. However, we cannot, and you see parties are bound by pleadings, we cannot, where the pleadings do not indicate that, make a decision that, look, the court, the legislation ought to make provisions for maximum and minimum acreage ownership. So I think it should come from the public as public interest litigation to the courts, and then thereafter the courts will make such determination. On Bosco, you asked about National Land Commission and issues around the Changamwe. and you indicated that that was in 2018. I know that the National Land Act was formed in 2013, and it gave powers to the National Land Commission to review grants, but those powers were, the review of the grants was to be made within 5 years from the enactment of the Act, such that if the President, as it then was in 2018, directed the National Land Commission to review the grants, then it may have been at the edge of the expiry of their mandate. That is why they could not proceed, because it was only 5 years, and from 2018 plus 5. I mean, from 2013, 5 years were lapsing in 2018. So there's a likelihood that they could not deliver the awards because time had lapsed. So that means then those issues ought now to be litigated in court for the review of the grants and the acquisition of those properties, as has been said. And in acquisition of the properties, the leading decision is from the Court of Appeal in Malindi, Nelson Kazungu Chai and others, because that is what says how public land ought to have been allocated. Such that if there's no pronunciation from National Land Commission, then I think that is a matter that could be litigated before the courts. I said Changamwe, but I meant Kibarani. Kibarani is where the
Yes, can I also make a comment on a question by Mr. Masore on subject matter jurisdiction vis-a-vis magistrates' courts? And the issue was whether you can raise a PO on subject matter jurisdiction saying that the matter has not been properly titled, because according to your question, the only distinction is in the title. Otherwise, the judicial officer that sits to hear has jurisdiction to hear whichever matter it is, whatever title it has. Whether it comes as a succession matter or an ELC matter, the magistrate has jurisdiction, the issue is in the title. And so the question that comes to my mind is, when the PO is filed, and I find that indeed the title is wrong, should I strike out the matter or should I ask the parties to amend the title? Because then I still have jurisdiction to hear the matter. And then, therefore, I'm guided by the Constitution Article 159(2), which is the overriding objective is that we should do justice. And so I think on that issue, vis-a-vis the magistrate's court, because the magistrate has jurisdiction, I think the easier route for me will be to ask the party to bring the matter properly, amend the title, and we proceed. Because either way, I still have jurisdiction. That is my view.
Just to add a comment on that issue, it is true there are many cases which are filed under the wrong title, especially in this era of online filing. I came from Nairobi where filing is done purely online, and what that means is that the person filing, be it a litigant, be it an advocate, is the one who selects the case title. So sometimes it is done maybe because the person is ignorant, but you'll find that that case is before the proper court with jurisdiction. Maybe it's only the misdescription in the title. And so it's not uncommon to find, especially many land cases filed as civil cases. And when it comes before me, of course, I will hear it as long as I have jurisdiction. Well, of course, the problem is that some land cases might end up being listed before maybe a resident magistrate who is not gazetted and who has no jurisdiction. In such a case, then it would be easier to have the matter placed before a magistrate with jurisdiction rather than striking it out, because I think that will end up being a technicality. So it is not uncommon. It happens a lot, but I think the proper way to deal with it is to place it before someone with jurisdiction. After all, does it really affect the merits of the case? I don't think so.
Maybe before Mr. Masoro goes for the second round of question, is it a follow-up to?
Keep it short, brief. Then if the magistrate's court has that particular power to, let me just use the word with all due respect, merely order the party to amend the pleadings, don't you think it is an equal advantage by a litigant who files a matter in the magistrate court where he will have the chance to be only told, you just go and amend the title and then come back properly, as opposed to somebody who's done the same mistake in the High Court, appeal is raised, the High Court dismisses the PO, and in the Phoenix Assurance case, then that person has no recourse. Why is it that a person who goes to the magistrate court has that benefit and that quality and unequal protection of law? I don't know whether my question is clear. Thank you very much.
I think we allow a response to that. My answer to that is very simple. You see, in the magistrate's court, there is no distinction because I'm gazetted to handle land matters, I'm gazetted to handle employment matters, unlike now when you're dealing with the specialized courts, which have limited jurisdiction as limited by statute. So you cannot compare the two. For the magistrate, as my colleague stated when he was introducing himself, I think we are jackals of all trades. So it's not an undue advantage to anyone. I think it is the law, the way the law is. Yeah.
Thank you very much.
Chairman, sorry. I don't know where Masore is getting the impression that High Court, we are that drastic. I thought it's actually the other way around. We are so much guided by the DT Dobby case, Madan's case. It comes striking out pleadings is in a very draconian, measure, and we are not rushing to it. Basically, because of the oxygen rule, and also it's a technicality. If you find, unless it's a very obvious, a mistake that it's not curable, that then we'll proceed. So that the impression created in this floor is that High Court, you go there and is guillotine, you will not survive. No. If it's a mistake, honestly, you can see is a mistake of an error, and it can be corrected under order 8. That's why the amendments are there. We can allow. We do allow. Even on the floor, we just allow, because we want the merit. We deal with the merit, particularly. And I think Nyanga is one person who has enjoyed that facility before me, and a few others here. So I don't think we are that bad, Mr. Masori. I think just because you've not appeared before me. Not yet. Okay. Please come. We do.
Maybe just Mr. Masore, I think it's a novel question, and probably we have also not questioned it through the court's jurisdiction. Why not raise this at the higher court so that then the court has an opportunity to determine and actually write a judgment on it, so that then you would have also assisted us in development of jurisprudence. That would be a corporate social responsibility. You would have assisted us in development of jurisprudence. Maybe allow me, because I know I had been requested, we have a question.
Thank you. I had several questions to the justices and magistrates. On the issue of maybe following up from Masore, I think some of these issues have been brought about as a result of the e-filing. Jane Onyango is my name, Judge. Okay. So some of these challenges, as Masore has mentioned, I think it has been brought about by the e-filing, because you go to the registry, you want to file a matter where it's a matrimonial cause but involves a matrimonial home, and this is land. So when you go there, when they do the assessment, they're telling you from the system, we can't file this under the matrimonial, the other division. So you have to file it as a land matter. Or if it is accepted, you file it as a land matter, and then once you filed it, an advocate comes with a PO that this matter is not a land matter, it is a matrimonial cause. So you find that you, as a litigant, you incur costs because of somebody, you've presented your work in the best format, but then again, you're being told this is not a matrimonial issue, this is a land issue, so go and redo your pleadings, have it filed as a land matter. And then on the issue of the magistrates handling land matters, I see Justice Munyao gave us very good guidelines, but what I would want to hear from the magistrates, which is the best practice that we can adopt, because you are subject to pecuniary jurisdiction. So how will you tell that this particular parcel of land that has been brought before you as a land matter has this value? And you know the cost of valuation and the kind of litigants that we represent. Some of them are very poor people that cannot even afford a valuer and paying for the valuation report. So how do you determine that this particular parcel of land is within my pecuniary jurisdiction, so that now I have the jurisdiction to handle it? And on the judge, or the question of adverse possession, you said, and I think I agree with you, that how will I, as an adverse possessor, get title, copy of a title, so that I'm able to do a search? And I also pose this, how will I, once I've struggled all through to get a copy of the title, did my search, I am not even aware that this person is dead. I filed my claim. Then once I file my claim, I'm being told you have filed a suit against a dead person. So how will I, as an adverse possessor, go ahead and again look for the estate of these particular people and bring a claim against the estate? How practicable is that? And then yes, and on the other issue of you have done search when you're bringing a claim for adverse possession, you have conducted your search. Then after conducting that search and you filed your suit, in between the proceedings, you're being told that this property does not exist. See plot number 87 does not exist because it was subdivided, I don't know which year. Then they bring a registrar who confirms that actually from the records, this property was subdivided and now has subdivision 1 to almost 20. And when you were filing this particular suit, you got a search signed by the registrar himself. So you come again in between the proceedings, you're being told that this property was subdivided, so you cannot proceed because the property is unknown. There's no land you can proceed with, litigate over. Then to Justice Mwanyale, this issue of status quo. Could you tell us, in the mind of a judge, what is this status quo? Because sometimes you come to court, the judge says status quo be maintained. And don't go further and interrogate what is this status quo that we are talking about. Someone goes ahead and continue interfering with the land, then you come back to court to complain. They're telling you, but that was the status before then. The judge is not abreast with the facts of what was the status before then, but it has ordered and made an order for status quo to be maintained. I file an application for contempt. The court does not have the benefit of what was the status before I made that particular order for status quo. So in the mind of the judge, we want to know what is this status quo and what are the parameters. Thank you.
Any other question?
Good afternoon, everyone. My name is Sherry Oyer. My question goes to any of the panelists can take the question. It's with regards to judicial attitude. So Section 106 of the Evidence Act has existed as long as the Evidence Act has existed in Kenya. But we see that in the last decade, almost the same age as the ELC court has existed, there has been development in terms of digital evidence, so which Section 106 of course provides for. And my question would be, what is the judicial attitude and also the litigants' attitude with regards to embracing digital evidence in terms of maybe satellite images and Google Map images in terms of solving issues of there's an issue of professional squatters that has been raised. As judges, have you experienced people embracing this type of evidence, and also with regards to advocates in terms of presenting this kind of evidence, what would be your advice? Because what I usually have encountered, even in terms of production of such evidence, there's still lack in terms of complying with Section 106. So what would be your advice to litigants and advocates in terms of embracing, and are you seeing more advocates embracing this type of evidence to solve these issues? Because I think this is something that could actually help courts, because it would give an image and a history of what has been happening. So if someone is saying, I have been in this property for 6 years, I'll just be able to go to those images and actually ascertain. Thank you.
We can take those rounds of questions. Any other question?
Asante sana. Kwa majina naitwa Ali Kigarimbwe. Mimi natoka shirika Likoni Land and Shelters Rights Lobby Group. Likoni Land and Shelters Rights Lobby Group ni mwamvuli ambao kuna hii mitaa ambao ni ardhi za kibinafsi ambao tunaita private land. Misufini, Kibuyuni, Matsalafu, Soweto, Jamvi la Wageni, Bomani, Kindunguni, Mrima. Hiyo ni mitaa ambayo iko ndani ya huu mwamvuli wa Likoni Land and Shelters Rights Lobby Group. Hapa sisi tutatafuta tu utatuzi wa haraka ili tuweze kumiliki hizi ardhi, kwa sababu kulipa. Sasa leo naona wataalamu mmekuja, mweza kutupatia mwelekeo ili tuweze kumiliki hizi. Chengine tena, kuna ardhi ya senti 10, plot number 252, na ardhi ya Vitsangalaweni. Hawa pia wako ndani ya mwamvuli, lakini lease zimeisha muda, zimeisha kabisa hizo lease. Kwa hivyo hapo pia tunataka tupate mwelekeo kutoka kwenu. Wale watu wanakaa pale na wasiwasi, kwa sababu twahofia mabwanyenyo wanaweza ingia pale haraka wakachukua hizo sehemu, alafu ikabaki juu juu. Swala lingine tena, kuna Waitiki, ploti za Waitiki ambao walikuwa semekana za Waitiki ambao walipata title deed, lakini hii title deed ni za leasehold. Hii title deed wanalipia, na wengi hawana uwezo wowote, wengi hawajaanza hata ndururu. Swala ni kama sisi kama umbrella, kwa sababu nao pia wanasongelea, wanaanza kuingia hapa kwenye umbrella yetu. Sasa swala ni, kuna uwezekano kuleta haya malalamiko kotini ili tuweze kuhurumiwa? Kuna uwezekano? Hilo ndio swala, kwa sababu kitu cha kushangaza ni kwamba Waitiki sehemu yake ilikuwa ndogo sana, kama mita 200 tu square. The problem is baadaye ilikuja kageuka, kwa sababu ile kesi tunavyofahamu ilisha kitambo, lakini baadaye kulikuja toka kizungumkuti ikasemekana ile gongo lote lake ekari 930 ni yake. Sasa which is which? Hatuelewi kitu hapo. So tuuliza sasa, mimi kalikuwa najua kizungu ngewaita your honor ama my lords, lakini kwa vile Kiingereza kimepita na huku na katiba ya turuhusu, okay, full stop hapo.
Asante sana. Kuna maswali mengine mtaniuia radhi hazitajibiwa, sababu najua zingine bado zinasikizwa kotini na hakimu wanasikiza hizo kesi, hawawezi ku make pronouncements kabla hawajapeana judgment yao. Kwa hivyo utaturuhusu kwa zingine hazitaweza kujibiwa hapa. Asante. Yona, I think we can take those rounds of judgment, and I think you will allow me close at that because I'm also looking at the time.
Ya, nafikiri Asante bwana mwenyekiti, tungelipenda tutafupisha kiasi kwa sababu muda pia unazidi kuyoyoma na wenzangu wanataka kusafiri. Nafikiri ningelipenda sikupata jina kamili lakini ni sawa tu, we uniiti yaona, lakini mimi nakuita nani? Kigarimbwe. Kigarimbwe umesisimua mambo mazito matatu ambayo ningelipenda kuchangia kwa uwezo wangu. Jambo la kwanza ni haki milki ya kibinafsi. Hiyo inahitajika, hatujapata facts zote, hatuelewi mwenyewe ni nani, hatujui kama wamepata kihalali ama kivipi. Kama wamepata kihalali, sioni kwa nini wasipatiwe haki milki yao ya kibinafsi. Hiyo inafikiri kuna facts zingine ambazo, maelezo ambazo pengine haujatueleza, umepitia kijuujuu tu. Lakini tungelipenda baada ya hii tunaweza zungumza, utueleze alafu tukuchangie zaidi, kwa sababu sijaona kama kuna jambo lolote linalohusu mahakama ya mazingara na ardhi hapo, kwa sababu sisi tuko na jukumu la kujibu hayo maswali peke yake. Lakini kuhusu ili jambo lingine la kwamba lease wakati wake umeyoyoma na mnaogopa mabwanyenye wanaweza kuja wakavamia hapo, hiyo ni wazo nzuri na ni woga ambayo ni halali. Mimi ningelisema ya kwamba lease ya Mungu iliwacha mpaka wakati ukayoyoma. Mtu unafanya application, inafanywa extension kabla wa muda. Ni area moja ambayo ndio ngumu zaidi katika mambo ya ardhi, lakini hiyo pia hiyo ni executive issue. Ningelipenda tu muombe ardhi yenu huo muda lease muweze kuongezewa muda. Sasa mko na waziri mpya wa ardhi, mueleze viongozi na kadhalika. Na kwa hivyo sidhani pia hiyo ni issue ya unaweza leta mahakamani alafu nikueleze ende uongezewe, ama niambie serikali ongeza lease. Ile kitu tunaweza fanya tu mahakamani ni kuzuia kwa ule muda wa kati ya kuongeza ule muda wa lease. Tunaweza kukupatia muda kidogo, tupatie serikali, tuseme ya kwamba kati ya huo muda wa kuongeza ile lease usitokee jambo lolote. Hiyo inawezekana, lakini uje mahakamani unaweza omba hilo ombi na tunaweza toa amri kwa njia ile kulingana na pia the facts juu, kwa sababu ni kwa nini hiyo lease unajua pia inategemea facts by facts, kwa hivyo sio kijumla. Hii jambo lingine la Waitiki, na inaonekana facts zako ni nzuri sana, ni eka 930. Kweli ile shamba ni ndogo, hiyo eka na watu ni wengi. Sasa watu ni 11,287. Hebu wagawie hao wote hiyo mashamba la ekari 930. Tunasema ardhi ni mara tatu, kuna ile freehold na leasehold. Hiyo hakuna vile inaweza kuwa freehold hata ufanye nini. Hata hiyo title mlipatiwa ni kibahati, mungepatiwa pengine leseni tu, ile letter of allotment, lakini at least watu wamepata haki milki. Mimi mwenyewe nimeona na macho yangu, the certificates of leases are there, na hiyo iko mimi mwenyewe nimeona na nimeshuhudia. Lakini hiyo hata ufanye nini, hiyo ni kama kuingia ndani ya chupa, haitawezekana. Usijaribu, hata sioni kama unless kama unataka kutoa watu wengine kupeana, hiyo itawezekana. Lakini nitampa pia mwenzangu nafasi aweze kuchangia. So kwa upande wa Jane, I think Jane is an area, adverse possession is an area that we are developing by day through jurisprudence. Before we were going by the traditional way of just continuous and uninterrupted stay and not having a permission from the owner on that kind of thing. But now Kuloba has brought the 7 points that we need to have. But the one I'm saying, the issue we are interrogating, and of course, the issue of getting a title D for a land that, I've already stated that. Those are some of the difficulties. They are really, really difficult. And even Justice Munyao, in his direction, brought that out, and we discussed during our bar bench meeting, under Order 36. So long as you have the official search, I think it's accommodatable to me. That's my way I look at it. But this other issue of you have already adjudicated, the matter has been heard, then later on somebody comes and says the land was subdivided. I think you are giving evidence after the I thought that should have been brought within the, I don't know that Jane, it is after or during, I don't know. I didn't get that clearly. Yes, 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 yes. Okay. Somebody pulls, yeah, yeah, yeah. This ambush now. I think everything should be placed early enough so that although in land matters, again, we are saying we want to deal with matters on their merit. That is an issue that I would want to interrogate more keenly, whether there is a ulterior motive or somebody is acting in bad faith. I think those are some of the things, but it's something that needs to be interrogated further. I don't want to tackle on the status quo because Mwanyale will be dealing with it. But normally when we give status quo, we actually define. Status quo means remaining as it is or no construction. And that's Mwanyale, I think, said it's more or less like getting an injunctive order, only that the rule of the thumb, we are hardly giving injunctive orders on matters of land. But when you say status quo, we specify, at least my quote, I do specify that status quo means, and that time the council, you've already informed court, honestly, that this is what is happening. No more construction, no more selling, the principle of less pedalt, and so forth. Finally, I think the issue of article, section 106 is actually 106, a capital A and B, Evidence Act. Digital evidence, yes, we are embracing. We're embracing digital, and by all means. In fact, I've used Google Map now thrice in lieu of a site visit. You find that here in Meritin, the SGR matter. I get it, and by the time you go there, you actually compare and contrast, and you find that that Google Map is as exact. It has all the data. Likewise, also for the parcels of land in several. So we are embracing, and of course, we are also embracing in certificate of production of photographs and service. And yeah, we are. It's an area that we are picking up very, very positively. I guess that's all.
Jen, when we say status quo, and I mentioned, it is to protect the substance of the suit, so that if a person is building, he's not protecting. Yeah? So it means then it's defined to mean the protection of the substance of the suit. That is what the status quo is. So it's basically an injunction through the back door. It's, an injunction through the back door. And then on advanced possession, the advance is to the title, so that even if there's subdivision, it's the original title. I can't remember on top of my head the exact decision, but there's a decision of the Court of Appeal that says it's to the title, so that even if there's someone who sold the land thereafter, it was advanced before. It's an overriding interest even on the purchaser. So it is to the title. Mzee wa Mwavuli, leaseholds exist in towns. So Likoni is now part of the town, just like Nyali. Hapa Nyali hakuna watu wako na freehold, yote ni leasehold. So Likoni, by being part of the town, every town, the title tenure is a leasehold. So it cannot be changed just to suit you kwa sababu labda hauna uwezo. It's leasehold kwa kila mtu. Yes.
Just to make, there was a question about the value of the subject matter in land matters vis-a-vis jurisdiction, and how courts have can determine the value. Now, this is an issue that has arisen even at the bar bench, and this is one of the issues that is captured in the guidelines that were put together by Judge Munyao and the team. But I will say that it is actually a question that is very ripe, because you find that that issue arises too late in the proceedings. Now, I will give an example from a case that I've actually handled, where we have had all the witnesses, and and at the point of filing submissions, somehow one of the advocates made an application for a scene visit, and we go to the site, And it occurs to me that the land is in Changamwe, and it is very close to the airport. And without any of the parties raising the issue, I questioned it myself and said, can this property here be less than, it's about an acre piece of land in Changamwe. Can it be less than 7,000 shillings, which is the jurisdiction of the Senior Magistrates Court? And at that point, both advocates said, we will now do a valuation, and the valuation then confirms that indeed the value of the property far outstrips the jurisdiction of the court. And at that point, then I had to refer the matter to a magistrate with jurisdiction to go on and hear the matter. Now, how do we, with the guidelines that have now come in place, I believe that the issue will be raised much earlier, and how then the value is determined will be a question of discussion between the court and the advocates. If the parties have the ability, evaluation can be done at that point, and we can save a lot of time instead of having to hear a matter and then at the tail end coming to the conclusion that the court does not hold jurisdiction. That is my 2 cents.
Okay. I could just add 1 or 2 comments. Of course, it's not easy. If for the parties it's difficult to get the true value, because of course the party who wants the matter to be in the magistrate's court will undervalue, and vice versa. For us, we normally try to just take judicial notice, maybe of the value of land in certain areas. And having come from Nairobi, we used to see maybe cases coming for land in Karen, cases for land in Kilimani. And of course, it was very easy for us to just say the value of land in those areas cannot be below 20 million. So we may not really know the exact value, but it's a simple way of doing it and being innovative. Otherwise, maybe where there is a discrepancy in the reports presented by the parties, the best approach would be to engage the government valuer and then accept that as the independent report. With that, I wish to request for your indulgence. Honorable Kiage and I are supposed to be traveling, and we were to take the 3 o'clock train. So I don't even know whether we shall make it. Kindly allow us to leave at this juncture. And we thank you for the interactions.
Maybe just as you allow the honourables to leave, and I think it's fair. Actually, I'm the one who humbly requested that we change the program. We are talking about Munyao's direction. What we have said also when we ask MLS is that in the plaint, when you're filing the plaint, declare the value. Declare the value in your pleadings. So be it. Then we can proceed on all the other details.
Okay. Thank you so much, judges. Thank you so much, magistrates. I know that our members still have several questions, but we'll have an afternoon session where we'll be with the judges. We'll be able to ask the questions. But for now, we need to release our good magistrates who are leaving. But before you leave, we just want to say thank you. We do appreciate what you've done today, sparing your time out of the busy schedule that you have. And I will our chairman, Mr. Charles Opulu, and our Secretary General Miriki Ruitu, together with one of our sponsors and Father Alan Nyange. Okay, I'll start with Honorable David Mburu. Chair, you can just say a word before you give out what you're giving out.
Thank you, Lillian. She has told me to say a word, so I must say a word. I think if we go by the rule of pleadings, in every pleading, you have to plead jurisdiction. And there is always a paragraph where we are saying, this court has jurisdiction to deal with this matter. So if you have pleaded anything that is contrary to what you are pleading, I think the court should move ahead and punish you for pleading wrongly. In this, I think there is any necessity to declare the value of the matter. You have already pleaded jurisdiction, so with you doing a lot of writing. Thank you. With that, I have the honor to give and award a certificate to Honorable David Buru. I didn't know your name is David. Thank you. Just like I am surprised with the name Lucas Leperes. Thank you. Thank you, thank you. Oh, kuna kamfuko pia ufike nako nyumbani. Yeah. Yeah. So you can clap for him. Thank you for being here with us. This one is for Honorable Gideon Kiage Oenga. Okay, and I was also told to say a word before I give the certificate. I read a decision and I used it in the Court of Appeal in Nyeri at one time concerning adverse possession. And it is to the effect, over and above what Judge you are saying, a point that if the adverse possessor acknowledges the title of the owner in writing, there is no adverse possession at all, even if it is even just a sentence or any activity that shows that you are acknowledging that so-and-so is the owner, then you can't, your claim for adverse possession will be defeated. So the lawyers here who struggle to defend adverse possession matters just trick the other party to write something in the, and then you present to court, you see, he says this is my title, so there's nothing adverse. Thank you, and Honorable Gideon, congratulations for having been here, and thank you for the job you are doing for us in the courts. And we are glad that you also agreed and found time to come and be with us. Thank you. Na haka kamfuko pia ufikishe nyumbani. Unajua leo ni Friday. Hatujui mtapitia wapi. Thank you. Hello?
We're going to have a group photograph just downstairs at the fountain. So if we can all meet there after the photograph, then we'll have lunch and come back.
Ladies and gentlemen, hello, hello.
check. 1 2 1 2. One two 1 2 1 2 1 2 1 2. Unasikia? Unasikia? One two 1 2. Mic check 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1. Mic check 1 2.
Okay. Afternoon, everyone. Honorable Judge, my I hope everyone is settled in. We can start the afternoon session. Yes. Good afternoon once again. My name is Ahmed Lukman. Today afternoon, I am the moderator for the afternoon session. We are at the tail end. Waswahili wanasema tumebakisha mkia. Sasa nimepewa fursa hii to introduce my colleague and a good friend of mine, Mr. Boaz Adala. Mr. Boaz Adala is an LLB graduate at Makerere University. He's an advocate of the High Court of Kenya with a diploma in law in the Kenya School of Law. He has practiced since 2014 and worked in the firms of Omondi Waweru and Company Advocates, Sichangi and Partners, Gitkera and Vadgama Advocates before setting up his own practice as Musa, Boaz and Thomas Advocates. He practices in the field of environment and land, commercial and insurance law. Mr. Adala sits in the Court Users Committee of the High Court Commercial and Civil Division and is the Deputy Secretary General to the Mombasa Law Society as well as a member of the LSK Coast Branch. Without further ado, I take this opportunity to introduce my senior, Mr. Boaz Adala. Let us welcome him.
Good afternoon, everybody. I trust you had a nice lunch, a hearty lunch. Yeah. We have received a message from Judge Mwanyale. He wishes to leave and attend to some other issues. So, my Lord, before you leave, we have a small token of appreciation from the organizers of this event. We welcome our chairman to present the same. Karibu sana. That's a former member of MLS now shining at the bench. Thank you very much. Thank you.
Good afternoon, members. Okay, I have the fortune or misfortune of having to present before a satisfied audience. I hope it is a fortune on my part. This afternoon, I'm going to present to you on the topic navigating the alternative justice system in protecting land rights. I think Mr. Lukman, you left some of your stuff here. Now, our distinguished guests, ladies and gentlemen, to all those who are following this workshop, both here physically and by virtue of the grace of technology, those following virtually, it is my pleasure to grace this inaugural workshop to submit on this topic. This is a novel area of practice that is set to take justice delivery to the next level and guarantee peaceful coexistence and guarantee a win-win situation. Now, one may ask, what is alternative justice system? I have this quote from Lord Denning in The Road to Justice. This is what Lord Denning says. Hence, I ask the question, what is justice? That question has been asked by many, men for wiser than you or me, and no one has yet found a satisfactory answer. He continues, all I would suggest is that justice is not something you can see. It is not temporal, but eternal. How does man know what is just? It is not the product of his intellect, but of his spirit. The nearest we can get to defining justice is to say that it is what the right-minded members of community, those who have the right spirit within them, believe to be fair. That is what Lord Denning talks about justice. Now, alternative justice system refers to the administration of justice by people using their culture, customary law, practices, and beliefs to resolve disputes. In other words, it refers to that justice which is traditional, informal, and other mechanisms used to access justice in Kenya. Ordinarily, we know that when you're seeking justice, we only know of the formal way. That is, you do your pleadings, you go to court, and it is an adversarial mechanism whereby the other side presents its case and I present my case, and then an adjudicator or the arbiter will deliver what is justice. Now, alternative justice system now refers to what is not in the mainstream. Now, one would ask, how old is alternative justice? Is this something that is new? Is it something that has just cropped up? Well, alternative justice has been with us since time immemorial. And it is just that we rarely see it, but it is in existence. And it has been an age-old system of dispute resolution among communities. Now, in Africa, there were levels or phases of conflict resolution. And these were dispute resolutions at interpersonal level, family level, extended family, and or village or town level. At that point where now you involve the chief. Still, these were informal, but that does not mean that the formal justice system were not there. You see that right now, if you go back to the village setting, the basic form of alternative justice system at the village level, you find the barazas, and these informal proceedings have always held sway, and they those informal settings, they come up with binding resolutions, and which ensures a cohesive community. Now, if we go back to the old system of alternative justice, well, you ask yourself the major significance of conflict resolution, and it was guided by truth. And he said that how would the other opponent know that there will be no partiality? Both disputants must be truthful. The mediator, arbitrator, or judge must also be truthful. And the presence of the ancestral forces is a factor. For instance, when you're referring now to your local level of dispute resolution, people believe that some forces are behind that particular process, and that if there is any dispute, if one does not adhere to the outcome of that resolution, then something might happen. Someone might fall ill, or whatever side effects, and that assists in terms of adhering. Now, bringing back the AJS into the mainstream, what is the legal backing of alternative justice system? We start with the Constitution. At Article 48 of the Constitution of Kenya 2010 provides for the right of access to justice, in terms that the state shall ensure access to justice for all persons, and if any fee is required, it shall be reasonable and shall not impede access to justice. If you move further, Article 159 2C now directly talks of alternative justice system. Of course, you know Article 159 talks of judicial authority. Now, Article 159.2 says, in exercising judicial authority, courts and tribunals shall be guided by the following principles. And C says, alternative forms of dispute resolution, including reconciliation. Now, that article provides the backbone of alternative justice system into the mainstream justice system. Now, what are these alternative forms of dispute resolution? In the past, we have various modes. For instance, if myself and Mr. Nyange there are disputing against whatever property, or even a wife, others would square it by a fight. Among the laws, they had what is called amen. And where you are involved in an amen and the winner, that is justice. In other areas, there'd be tossing of the coin, there'd be black magic, swearing by something. Now, you ask yourself, does the Constitution contemplate some of these outrageous means as the mode of AJS that is provided for in that article? Now, you find the answer to that by looking at Article 159.3. That article says that traditional dispute resolution mechanisms shall not be used in a way that, one, contravenes the Bill of Rights, is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality, or C, is inconsistent with this constitution or any written law. So before any method of AJS is adopted, it must meet that test that is provided for by the Constitution: non-repugnancy, non-consistency with the Constitution, and it should not contravene any of the Bill of Rights. Just for instance, that one of me fighting it out with Nyange would not meet that test. Now, those provisions of AJS were entrenched through the AJS policy, and in the policy, the task force that was put by a retired Dr. William Tunga, the task force on the traditional, informal, and other mechanisms for dispute resolution in Kenya. That team was required to examine the constitutional, legal, and policy options available to fulfill the requirements under Article 159(2) of the Constitution. In other words, that team was tasked with going around the country, studying the various AJS mechanisms that are available there, and to see how it can be brought into the mainstream without upsetting the standards that have been set by the Constitution. Then CJ Emeritus Justice David Maraga launched that initiative, and which was aimed at supporting expeditious delivery of justice to citizens. Now, the AJS policy notes that before the colonial occupation, the communities in Kenya had their own systems of justice. So in other words, this AJS policy in itself accommodates that which was there. It continues that colonialism, however, imposed a dual system of justice. One system, native courts, applied customary law to indigenous communities that were referred to as natives, and primarily addressed family law, land tenure, and succession issues, while the other system were colonial state courts, which applied law adopted from England. Now, why was there a need to adopt the AJS mechanism? It was noted that a majority of disputes do not end up in the formal mechanism of justice system. And the retired Chief Justice noted that a whopping 90% of disputes are resolved through these hitherto unrecognized but very effective methods of alternative justice system. Now, some of the recommendations of the task force for interaction between the courts and matters determined by before the AJS institutions were, for instance, they suggested 3 models of AJS in Kenya, namely one autonomous AJS institutions, that is. 2, a third-party annexed AJS institutions, and the court annexed AJS mechanisms to be maintained. The other one was the application of human rights-based obligations that is anchored on the 3 pillars of duty to respect, protect, and transform. Then the agency, an agency theory of AJS to be applied in delimiting the jurisdiction of AJS institutions and mechanism. Now, what are some of the advantages of AJS? As has been noted, AJS is efficient in that the decisions made outside courts are respected without the need of external enforcement. I'll give you an example. And this even in terms of when court issues orders that parties to try an alternative dispute resolution mechanism. With that environment that is not coercive, an environment that does not submit people to what they would term as laws that are foreign, it always leads to an output that is binding to all parties. I'd like us to now look at how AJS can be used in land matters to bring it back home. And I hope this will be an interactive session. Now, by this, I'm reminded of a case which was brought by one of the participants, the Waitiki land case. Now, the Waitiki land case, I would say the real dispute was resolved. Remember, one Mr. Kamau Waitiki owned about 980-acre parcel of land in Likoni. And he acquired the title, he had the papers legitimately. However, in the 1997 clashes, he was thrown out by squatters who took over the land, and he was not able to access it. After a while, the Waitiki claimed his land, but with the area being populated by squatters, yet he's holding on to one title. Now the question was indivisibility of title as against parties who have a right to they have a right to have a shelter. They also have a right to own property. And my take, because this matter went to court and Waitiki's title was upheld, but now in terms of practicality of enforcing your judgment, when the state came to negotiate and buy the land from Waitiki, so that those who are there, because you can imagine that mass eviction which would have happened, I would consider that one as one AJS that really succeeded, despite the emerging issues that are coming up. But we avoided one major dispute, which would have also been a security concern to the, not only to the coast, but to the country as a whole. Now, in terms of land matters, we have incessant human-wildlife conflict, attacks and invasion of forests
And in this case, we are looking at the Mau forest invasion. How can AJS be used in that kind of scenario? Now, other advantages of AJS that have been highlighted by the report of the task force is that it reflects the lived realities of Kenyans in an effective mechanism for increasing access to justice for many. The other one is that the AJS as a framework for expanding human rights and human autonomy. Because when you have competing rights, each person pulling the other way, the only way out of it is through a negotiated settlement. And we know that in court, there must always be a winner and a loser. But when you talk of AJS, AJS ensures that everyone goes home happy. So that one is one of the very many advantages of AJS. Then AJS as a mode of doing justice differently and more effectively, this is seen as a different and better mode of doing justice in at least 4 ways, in that it is a form of restorative justice. Unlike the adversarial system that we've talked about, it ensures more social inclusion since it is participatory in nature, it is affordable, and with minimum formalities and technicalities. And again, it is also expeditious. I wish to just go through the 4 models of AJS that have been proposed in the policy, and this is the autonomous AJ institutions. These being mechanisms run entirely by the community. Now, I would say that despite not having been formally recognized, this mode has resolved so many disputes that have failed to be recognized because the issues are settled on the ground. And when you see people, they look as if they have no problems, but yet it is that AJS at the community level that has resolved these issues. The third-party institutions, that is annexed AJS institutions, this can be state-sanctioned institutions, and this includes now the chiefs, the police, the probation officers, and child welfare officers. We have seen, as a matter of fact, though criminal lawyers, whenever a client calls you and tells you there is this land matter, the police is disturbing me, blah, 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 the first thing we always advise them that tell them that is a civil matter. They should not get involved. But what you don't know is that the police, in their own way, have a way of using AJS in resolving some of those disputes. However, if you find yourself leaving that particular forum and taking the matter to the formal courts, then there's a possibility that the outcome, one person will have to cry. So the police have a way of executing that AJS, but once they meet the 3 set up by the constitution, the chiefs at the village level, the chiefs resolve a number of issues which would otherwise have been taken to court for years and years. The first person that a litigant interacts with when in the village or when they have an issue in the village is the chief. Now, I'll give you a life experience. There's a time a client called me that they had an issue in the village. Someone was they were fighting over some property, and the client advised me to rush and go to court. So since as an advocate had been paid, I rushed and filed a case at Bondo Law Courts and got my witnesses, recorded statements. When it was the day for hearing, I'm calling my witnesses and all their phones are off. Then when the matter is about to be called, someone tells me, why don't you try call the wife? Then the wife's number goes through, almost all of them. Then you ask them, why are you not in court? And he says, the chief told me not to come. And you ask this person, why is the chief telling you not to come, yet you recorded a statement? I later came to learn that those people listen to the chief the way a staunch Catholic listens to the father. So chiefs have a role to play, and they come up with resolution mechanisms that even courts sometimes cannot fathom. Now, probation officers, child welfare officers also are included in that category of AJS institutions. There's the court annexed AJS, and in that one, that's where we have, for instance, the court annexed mediation, whose aim is to have a win-win settlement. Then there are also regulated AJS institutions, and in this now the policy proposes of having AJS panels. These are yet to be put in place, but I understand there are areas where they are already in session. Now, as I wind up, I'd like us to have a discussion on how AJS can be used in land matters. Maybe I'll throw that one now to my panelist, who was also my co-discussant, Mr. Lukman, my younger brother. You can take it away. Otherwise, thank you so much, and may God bless you.
Yes, thank you, Mr. Adala. I hope everyone has understood what alternative justice systems are. Yeah. Mr. Adala, who has presented well. We have any questions for him, or any, if you need clarification on a point he made, or if you have any queries whatsoever. Anyone? Yes, Mr. Nyanki.
Mine is to ask Mr. Adala his view on ADR and alternative justice systems. The challenges, for example, from lawyers who see that as another clawback to their work. There's been an ongoing discussion on advocates losing work WIBA took work away from advocates, saying the work taken away from WIBA is about 50 billion shillings. AJS is coming in. It is about to take work away from lawyers. The experiences that are there is that in land matters, there are very few cases where AJS or ADR has worked. What is his view on the fight between for space between lawyers and this AGS system, especially where you know you'll not be given costs if you go for ADR. Hardly are you awarded costs. And you know very well most lawyers buy files and brokers and ambulance chasers. So imagine you've spent money, 30,000 to buy work. You've paid for the police abstract. You have even disbursed some money to pay fees for your client. And the court is saying this one will go to OJS. Do you see that really happening? You know, we have to live in a very practical world. What is your view?
Yes. Before Mr. Adala can answer, can we get another question? I see Mr.
Adela, my question is on gender sensitivity. System, in that you know very well that the composition of the elders who are supposed to allegedly preside over the disputes, most of these cultures are cultures where women are not even supposed to interact with men. So I have a dispute concerning my father's property or my late husband's property. Somebody has, say, encroached, and I am now before the panel. So this is a panel, maybe because of gender issues, also an all-male panel. So what is your view on gender sensitivity when it comes to AJS?
Yes. Let us go to the judge.
Yes, Councillor Adala, thank you very much for very incisive presentation. I'm one of the persons who have been advocating for ADR, more so the court annexed mediation system. Mine perhaps is a quick follow-up from what Advocate Nyange has left. It's more of a concern. From my practical experience, I know alternative mechanism of resolving disputes is more prevalent to matters that to family and more so matrimonial. As judicial officers, we find ourselves in a very awkward position adjudicating. Right now, I'm dealing with about 4 of them, where the disputants are all related, brothers, father, mother. One is even a wife and a husband of our property, and each one of them has a title. I have referred them, and this is a practical point of view. I've referred them severally to my deputy registrar, to mediator, to the mediation desk. But what I've noticed is that all those matters, either they get frustrated there or the parties just frustrate the proceedings that we are unable to proceed. They don't attend, they don't participate generally. There's a lukewarm, atmosphere. Is this related with what Nyange has now revealed, lifting the veil? Is it an economic issue? Or is it that in as much as you have, and I agree with you, you have given ADR a lot of premium. Totally agree with you. But is it that people still believe that until and unless I see a judgment, I stand, I testify, the judge has heard me, justice cannot be seen to be done? I don't know that is a question I'm asking you, but I'm posing, particularly from the practitioners. We are having it difficulties that people are not yet embracing ADR or alternative means of resolving resolution. Yet is the best.
Thank you. My lord, is
Now, also a follow-up from the question by Mr. Nyange, because that is one way of that is one side of the picture that advocates can be an impediment to AJS, especially when the question of their fees is involved. Now, looking at it from the other side, are there ways in which the courts can also stand in the way of AJS? Can the courts be an impediment to AJS? And if so, how can that be rectified? Because we can look at advocates, can we also look at the court and see, is the court also sometimes an impediment to AJS? Thank you.
Thank you so much. Is there anyone else? I think we can have two more questions and then we can close the, we can have Mr. Adala answer them and then we can have another session.
Adala, I want to be a devil's advocate today regards AJS. My experience, especially dealing with matters from Mariakani Court, AJS seems to be a source of problems. My question to you is, how do we streamline, especially in light of the three matters I've handled? The first one, all of them are land matters. They go to the deputy county commissioner, summons one of the parties fails to show up, then he writes a letter that because the other party was not present, now this land belongs to XYZ. The second one, same officer, DCC, purports to organize a meeting of the parties. He doesn't visit the land, he does not understand the demarcations, the history, but he renders a judgment, or rather a finding, that a particular land or that particular parcel belongs to one of the parties. Is AGS to some extent an impediment? Is there aspects of impartiality? How do we sort of refine so that we have a win-win, as you say?
Yes. The last question before Mr. Adala can.
Maybe not, but I think I would put it as a concern. Well, out of experience, I have had a situation where government is claiming this is public land and somebody else is claiming this is their personal private property. And then the court tells you to go for ADR. It becomes difficult, and probably this is back to the judicial officers, even as you're engaging in a decision whether to send persons for alternative dispute resolutions or not. Now, as an officer in the office of the Attorney General in court, I cannot engage in alternative dispute resolution or alternative justice system unless I am mandated by an accounting officer. Now, my experience is that alternative justice systems have timelines, and I believe that will be 60 days to resolve or not to resolve the dispute. Clearly, 60 days are not enough if you are dealing with a situation where you have to get instructions from the accounting officer of a ministry. Would it be something you would consider to look into in terms of time, so that then, if that is the direction the court would want a matter to take, then you think about the timelines and whether the timelines actually can serve that purpose. That's one. Two, in just dealing with alternative justice systems, well, there is no requirement that either a mediator or an arbitrator is an advocate. But in appointment of the mediator or the arbitrator, is it possible that the appointing authority would look at the complexity of the matter before then appointing the officer who would then undertake or drive that process? Because when we are looking at the possibility of who owns title, whether there's competing interest in title, and an accountant without knowledge of the land administration process is appointed as a mediator, would it then hinder the process from actually reaching its achieved goal? That's just food for thought. Thank you.
Yes, thank you everyone for the questions. I have I've sat through an AGS session. Basically, they were talking about the guidelines and policies that were they intend to bring and to discuss, so that they can take the same to the parliament and put as a bill. Technically speaking, they are still going around right now. There's a policy guideline that is still operational. I want to say AJS is an alternative justice system where people are they are brought before they can go before they can even go to court. It's a faster way of resolving issues, and as Mr. Adala had put it, it's not only that, it's also cheaper, and it does not take away, as Mr. Nyange had said, does not take away the bread and butter of the advocate. Merely, it allows the people to have a sit down before going to court and agree on an issue. Secondly, I wanted to note also AJS does not have sanction methods because it's not statutory. AJS is purely on mutual understanding between the two parties. So there is no sanctions that are issued against a party. So basically they are allowed to negotiate. If there is no outcome, that is, the parties can proceed to go to court. Thirdly, I wanted to also point out that AJS is a broader spectrum of alternative dispute resolution. We are not looking at alternative dispute resolution here. We are looking at how people can access justice in places where they are so remote, even there are no courts. For example, if you go somewhere in, I want to say a rural area where there is no courts, there is a chief who is there. So the NGS policy guideline is trying to bring in some form of authority to allow people to come up with a solution to their problems. So without further ado, we can proceed to Mr. Adala. I've answered a few of the questions that have been brought, but Mr. Adala can clarify.
Thank you, Lukman, my co-discussant. I believe you have answered some of the question. I just wish to continue where you have left, that AJS is broader, and that it is meant to have people come up with their own homegrown solutions to their problems. And you find that AJS can succeed in situation whereby the formal courts would not succeed. And by that I mean that if in the formal court one person wins and the other one loses, that is not success. So AJS can break into that small space and come and bring these people together so that the coexistence means that they all have a win-win situation. Then the concerns raised by Mr. Makuto, I agree in terms of having, and I see people are mostly considering the court annexed mediation, and the issue of having a complex issue being referred to a mediator without digging in to see whether this mediator has the expertise, it has affected many. And actually that one leads to some of the reasons that my Lord Judge Naikuni says that parties go back that they have failed to succeed. It is not really about advocates standing on the way. You find advocates wondering, is this person really understanding the issues at hand? Now, when you feel that the person you're appearing before does not understand the issues that is meant to mediate, then it is a non-starter. It's like you're just waiting for that person to throw in the towel so that you can go back to the court that is usually the expert of experts. So I agree entirely with Mr. Makuto's. Then the first concern that Mr. Makuto raised on personal land versus private property and being sent to a mediator or an arbitrator. Well, as Lukman has said, the policy is meant to come up with guidelines before now these issues can be entrenched. And I believe once the same is worked out, Mr. Makuto, even in the office of the AG, you'll find somewhere where you will fit so that there will be instructions flowing that can allow you to attend for such AJS. Then there was the issue raised by Mr. Simiu PS Wafula on AJS being a source of problem, and the example you have given, I would refer you back to the standard that was set, that AJS ones need not to be repugnant, need not to be against the Bill of Rights, because fair hearing is a core component of the Bill of Rights. So before you order that this property belongs to this person, you as the person who is lead of that AJS, you must hear him. If you fail to do that, then definitely that AJS session has failed to meet the standard that is required. And you have a right, Mr. Simiyu, to go before now the formal court system so that you can be heard fairly. Then if I can now go back and start with Mr. Nyange's point on his view that there is a fight for space between lawyers and the AJS. Well, AJS ideally is meant to even start before someone walks to the office of the advocate, so that by the time the person will be coming to your office, Mr. Nyange, it is meant that AJS has failed in that first tire. Now, but you can still try the other one of court annexed mediation, because now that will be now a second module, in which case now, and remember, AJS, to qualify for AJS, all parties must must accept to be to the forum. Now, where parties, one of the parties, for whatever reason, is not comfortable, then in that case, the AJS is as good as nothing. So it would be a waste of time. Then there was the second question that was raised by Jane Onyango on gender sensitivity. Now, AJS, one of the challenges and or disadvantages of AJS, and this one I would say from the community level, is that the issues such as poverty, issue of it is called male domination, and you find that those rules that are there, they are so male dominated. But now when you go for an AJS with that particular background, then it will already not be fitting in the straight jacket that AJS is meant to fit in, because it will have already failed the test of repugnancy. It will have already failed the test of not contravening the Bill of Rights, because there, of course, there's already a discrimination as against the fair agenda. Then, yes, Judge Naikuni has raised an observation that the AJS is more to do with private to family and matrimonial disputes. That is a good starting point, but as you've noted that some of them fail to agree, so many things can contribute to that failure to have an outcome that is expected. Lawyers standing on the way, not always, but of course sometimes there's always exceptional cases we cannot refuse, but it is not always the case. Honorable Kiage asked about ways in which courts can be an impediment to AJS. Perhaps you wanna, that one now, it is in your shoes. You can tell us how your side can stand on the way to AJS. But just having a wild thought of how the court can stand on the way, I think it is more to do with the perception. If courts, or if there's perception that only the court can do justice, then however much you send people for AJS, however much the chief tries to bring people together, there'll be always the statement of tupatane mbele, meaning he has to go there and hold the Bible and swear and say the truth and nothing but the truth katika mahakama ya haki na ukweli. So perception matters. If there's the perception that only court can do justice, then in that wider sense, I see it as an impediment to AJS. I think I've sorted all the questions. Thank you.
I hope your questions have been satisfied. If not, if you seek further clarifications, this is the second second and final session. I'll take only 5 questions for the same. We close.
Thank you, Mr. Adala. I think I've heard what many presenters have spoken and what you have said on the alternative justice system, and I'll zero into mediation. My take is that a mediator does not have to be an advocate, as Mr. Makuto has postulated. A mediator must be a trained mediator. In fact, if you asked me, if he doesn't know the subject matter, then better for him or her to be able to do mediation. What the problem that we are having here is that we are confusing mediation with negotiation, we are confusing mediation with conciliation, we are confusing mediation with arbitration. All those are forms of alternative justice system. But for a mediation, A mediator is a neutral third party who is assisting the parties talk to each other. And the mediator does not make any decision. It's the parties that make the decision. And there are sometimes when you have to get, as a mediator, you have to identify all the issues in dispute. And then after that, you have to go step by step and get those ones that have been agreed upon and those ones that have not been agreed upon. The problem we are having, and I'm talking as a trained mediator, the problem we are having is that you are having advocates who think that mediation is litigation. And when they come to mediation, and Makuto is one of them, when they come to mediation, they want to put their oratory skills there. They are not required there at all. Please consult your clients before you send them to mediation, and keep far away from that mediation room, because a good mediator will tell you beforehand that I don't need you here, you don't have to speak, wait for your client in your chambers, you still have your costs and everything else, because the award that I will write or the consent that will be written will still be referred to court. So you as an advocate, you don't lose anything. There is no fear that an advocate will lose their fee in it. For the judicial officers, I think the problem, and somebody was asking whether they are an impediment. Yeah, many times they are. One, they are overzealous on timelines, and they are overzealous on asking whether the mediation is through. Number two, there are others, yani wako na madharau on the mediators. They see them as a challenge, a situation of jealousy and seeing that jurisdiction inaibiwa. No. These are complementary systems, and they are meant also to remove the backlog and work from judicial officers. So it is not really a competition on jurisdiction. Yeah. So for myself, I just wanted to say that as lawyers, let us know what mediation is about. The problem is we are groping in ignorance, and we peddle it before mediators, we peddle it before whatever, but they fear you, they can't chase you away. Lakini kama ni mimi, I've chased so many advocates away. Thank you.
Maybe now that Mr. Opulu has said I am one of those one of those bad advocates. Remember, I did not indicate that I did not say mediation or arbitration. I pointed out the person to assist in coming to a decision in the matter, because I am aware it can be an arbitration. I am aware it can be a mediation, a negotiation, and yes, even conciliation. Some of these areas of mediation, arbitration are specialized. And if, for example, you actually appoint an arbitrator that has no knowledge in construction matters, and they are supposed to take parties through an arbitration process, then issues may arise. That is all I wish to clarify. Thank you.
Yes, we'll have two more questions.
Good. Oh, sorry. I am Bennett Nzamba, and I would give a comment as opposed to a question, and also reiterate what my colleagues have said. The major issue, as I'll give a comment as an ADR practitioner, since I'm one of the mediators and I also do the arbitration partially. So, matters land are so dear to the hearts of human beings under the sun. So it will be very sometimes in the practice of ADR in land matters, it's always very difficult to find a consensus between the parties. For example, Judge had said, when you get when you get a dispute where parties have two titles, it would be very difficult for either of them to let go of their title, because all of them will be claiming that it is an original title and it belongs to each of them. So that would more often than not really be a dispute that is very challenging. And so to encourage maybe the alternative justice system, I would say it is achievable, yes. And how do we achieve it? By maybe sensitizing the public on the different methods of sorting these land issues, apart from court. So that would be achievable if sensitization is done in the grassroots to all the participants, especially, the litigants, the persons who are involved in land matters. Otherwise, it is still in the knowledge of the public that unless I go to court, that's the only place that I'll attain justice, and that's the only place that the court will decide that this land is yours as opposed to the other person. So that is my comment and view on the alternative system.
Thank you.
Thank you. Lukman, I have two questions from our online participants, and then I have my own question. One of the questions from our online participants from Ms. Njau, she says, thank you, Adala, for the informative session. Please advise on what role can we as advocates play in establishing a Mombasa County AJS and follow the footsteps of other counties, e.g. Nakuru. Teresia Memia asks, is there a way of enforcing AJS in the judicial system? And myself, Mary Kiririti, I want to ask, in matters environment, how do we ensure that the environment is protected? We're saying we can have AJS, it's a win-win situation. You find, say there's a big multinational company, it's establishing a plant somewhere, and whatever they're doing to the environment there, it's degrading the environment. The community living there is getting affected, their health is getting affected. But they come in and say they give some money to the members of the community. And then you see, it's a win-win. The multinational continues with their work. The members of the community have some money in their pocket, but still the environment is getting affected. What then can we do in such an instance? Thank you.
Thank you very much. Maybe I can answer the last question. What we can do in alternative justice systems. First and foremost, the environment, the protectors are the people. The protectors of the environment are the people. So where the people are not, the environment will suffer. In the future, it's the posterity that is going to suffer. So, AJS in terms of playing a role in the environment, it really has limited scope over it. So I want to say AJS is not the final form of justice for the environment, but it is there. You can approach it, but you cannot do it at grassroots.
Well, I think you've sorted the two last questions very well. So I'd like to look at the first question raised by Njau, right? Online. Ms. Njau, you asked about how, as lawyers in Mombasa, we can play our roles in these AJS, like Nakuru. As lawyers, firstly, we are citizens, and we need to be taking part in these stakeholder engagements. And by the way they are going on, perhaps the problem as lawyers is that we are waiting for a session of lawyers, which may or may never come. So it is upon us to ensure that we follow up on where these stakeholder engagements are taking place. We share our views so that they are taken into considerations, and actually we can be part of some of these AJS panels. And in the other mode, I believe lawyers are part of those who are mediators. So you are already taking part, Ms. Njau. You just need to upscale it. I think the others were just concerns, basically. Just Mr. Upulo, I'd like to know at what point do judicial officers meet the mediators so that there is this what you call madharau, because I don't think these people ever interact at any, because the judicial officer will say let this matter be referred to mediation, and then the matter goes to the mediation registry, and a mediator is appointed. Well, I stand to be guided, Mr. Pulu, on perhaps if you have any experience, but I think that Madara was a bit too harsh to our, but thank you. Thank you so much.
Yes, I think we have concluded today's program. I would like to call panelists, our part to conclude the matter today. Thank you very much.
Thank you so much, Lukman. Thank you, Adala. Maybe we can just appreciate Mr. Adala for. Thank you. We had requested, especially the online participants, that we add them even at least 15 minutes, so they're able to ask our good judge and our honorable magistrates who have been gracious enough to come back and hear you out. So I'm going to give you 15 minutes. If you have any questions to the judge or the magistrates, feel free to do so. And on participants, do you have any questions there, SG?
Thank you. From memory, I can remember our ancestor Benjamin Njoroge had asked about where land is sold, small parcels of land. The community recognizes that the land has been sold, but the land is so small that it cannot be registered and a title cannot be issued. Mr. Njoroge's question then is that isn't it high time that the judiciary, through its judgments, advocated or directed for legislation so that these emerging issues can now have a proper legislative framework?
Yes, we also had another question to the Honorable Magistrates. The question was, how does an advocate ascertain whether an environmental matter, not land, should be filed in the ELC, that is the High Court, or in the Magistrates Court? Then this was more of a recommendation. The other question to Honorable Mburu, who had mentioned that since he came to Mombasa, he has noticed that there were some matters that were filed, but orders were not given, and thereafter he has experienced absentee plaintiffs, and encourages advocates, we need to do something about that. The comment from one of our members was this, or rather recommendation. Sometimes, and we are here to help each other, sometimes parties do file their matters, and indeed they don't get the orders, as you say, but they become mischievous. They'll go file it in another court, and they'll get the orders, and they'll forget about the other one that they had filed. So the recommendation is, now that, yeah, they'll get orders and they'll even proceed with the matter, but remember the other matter is still existing and subject now to warrant of prosecution. No, the recommendation is not you should give orders, but the recommendation, the recommendation is, now that you're in the digital era, and very soon I'm sure Mombasa will also be embracing e-filing. For ELC matters, that is in the High Court and the Magistrate Court, can we consider that when we are filing our matters, instead of just capturing the parties and the case number, can we consider capturing the title number? That might help, so that when a party files a case and then you do not give them orders because they don't deserve it, then they are restricted from filing it another court, because when they're going to file, the system will be able to catch this matter had already been filed, or this property already has another case, and you're able to ascertain whether it comes from the same cause of action. That was recommendation, and maybe we can have your comment on that. So maybe you can take those 3 questions, then we'll take other questions.
Thank you. I will take the first one, rather the last one, which was more of a comment and a recommendation. And I would agree that if it were possible to capture the title numbers or the details of the land, it would make matters easier in identifying which maybe cases have been abandoned and perhaps filed in other courts. However, and I say this having interacted very well with the e-filing system, currently it doesn't have such capabilities, and as you know, the system is developing. It's being improved as we continue using it. So this is a good thought and good recommendation, which whenever I get a chance, of course, I will give to the people responsible for improving the system. Once in a while, they come collecting our views, and I will definitely give that proposal. I hope in future it can be incorporated into the system. I think there was another question directed at the magistrates, the one about filing environmental cases, how one will decide whether to file in the lower court or in the ELC court. And let me say, to start with, in my entire life in the judiciary, or since I started hearing these matters, I have not seen any case concerning environment filed in the lower court. So I'm not very sure what parameters would be used to decide where to file. But I tend to think that most of them are filed in the ELC court. But maybe my colleagues will comment on that also. Thank you.
Yeah, thank you very much, participants, councils. There was a question that where land is sold and it's too small, whether during the delivery of rulings or judgments we can make recommendations on policy. I did indicate in my presentation there are a number of policies in this country. I started with the Njonjo Commission, the Ndongo Commission, the Truth and Reconciliation, quite a number of them. And for a healthy judgment, it's always good to, if we can be able to use the policy to influence law. That's how you build jurisprudence. So I totally agree with you. Where land is too small, it's not in any way able to survive, there can be legislation to that effect. So I totally agree. On the issue of multiplicity of suits, I have already discovered that myself, that there are too many cases which are filed. People are hopping from the lower court to the high court, and it's almost embarrassing. It's embarrassing us that you find that you've made a decision on an issue which has already, there's yet another decision which is conflicting to yours. So if there would be a way, and I think digitalization, Lillian, is to me the best that can happen, where we have all the parameters, title deed number, the parties number, names, and so forth. Just the same way when we ask you to go and publish, to go for substituted way, publishing in the newspaper, all the orders that are issued, I insist you must be able to quote the land reference number, any other particulars, because that's another area that is abused. In fact, I'm surprised that no question is coming from that viewpoint. To justify that we served, the parties did not respond, and therefore let us matter proceed on for formal proof, only to discover that actually the persons are around. I didn't want to comment anything on Opulu's comment that we are competing with the mediators. That is a comical one. We are dying of cases. We have so much to do. With the backlog is so high, you can see the judiciary is employing everyday judges and magistrates because we have so much. So what is this that we want to clink on one file? Mr. Opulu? I guess it was with a light touch.
Okay. And yes, you've answered all the questions. Any other person with a
Thank you, Session Chair. On access to justice, there is an issue, and I don't know how we look at it, but orders for stay pending appeal. A judgment has been rendered against my client. I move for stay, and we know very well the stay is granted based on conditions. In most cases, land matters, we normally don't, it's unconditional. That stay will be granted, but will not be given conditions. In money judgments is where we be told deposit. But of late, in Mombasa, the courts would give conditions that are impossible to meet. It's literally telling you that you don't have stay. Because if I'm told that I have to deposit 2 million or 3 million shillings, I'm representing mama mbogas, people who have small incomes. The court is literally driving me away. And if I don't get that stay, even if I'm prosecuting that appeal, I'm doing a record of appeal, I'm going to the court of appeal before I'm heard there. The houses are crushed. So I don't know. I know it's an issue of preference. Different judicial officers look at it differently. But the trend in Mombasa has been punitive to parties who lose and they want to go on appeal. So I don't know how we look at that. Then there's been an issue of consents that are not consents per se, where I sue Mr. Honorable Kiage, yet I know he is colluding with me, so he has sold me the land, there's quotas there, so I sue him for vacant possession. He files, instead of filing a defense, he files a statement of admission. I file an application for eviction. He consents to that application for eviction. The court gives a consent that we evict. And the crafting of the consent is in a manner that allows the eviction of anybody who is on that suit property. Yet, even if you call the advocates, and mark you, both parties are being represented by counsel, they will come to court and confirm the consent. Even if you call the parties themselves will say, yes, it's true, we've consented. And knowing very well that the people who are going to suffer are not parties to those proceedings. So sometimes I don't know how the court can deal with such situations. We've also had instances where people file cases using fictitious people. You know, I file a case. The plaintiff is called Bakari, Mabirikani. Bakari Mabirikani doesn't exist. I file it against a person who also does not exist. But the idea is definitely that suit will not be defended, and maybe this Bakari will not come. There'll be an application which will be, it will not be contested. The orders being sought in that application are drastic, and the result is someone is going to suffer. We've also had instances where the municipal court has been used to evict people. There is a bylaw which says that you cannot construct without a building plan. We know how many buildings in Mombasa have approved plans, very few, especially in Kwabulo, those areas where people are putting up Gorofa buildings, but we know they are not approved because the part of the approval process is you need a copy of the title for you to get an approval by the county. So these people put up their structures there. So the landowner has found a buyer. The buyer will not buy because there are people in occupation. He goes to the municipal court, causes himself to be charged there for putting up structures without a building plan. He knows that he has no structure there. He will plead guilty. The order will come from the municipal court to go and evict those people, demolish their houses. That is eviction. So the question is whether that municipal court has jurisdiction to grant orders that of eviction in nature. And then the order goes further to say that you will pay. The person who is being evicted will compensate the county government for the costs of evicting them. Those are some of the common practices that we see every day. I have also seen the guidelines on adverse possession. I think this will become a clog because if we were to comply with those guidelines, filing cases for adverse possession will be very expensive. You need a surveyor's report. That is, I've seen in the new guidelines, you need a surveyor's report, you need a valuation report. That is expensive, especially where the land is huge or big. It might not be easy, therefore, for these people to access court if they are to comply with those requirements. I have also noted of late, and I'm not saying that it's the judiciary that is to blame, or I really don't know, but the trend nowadays is to dismiss all adverse possession claims. There are very few nowadays that are succeeding. Even the ones that you have genuine people, very few of them are succeeding now. So the body language of the court, if you look at it, in most cases, there's like a spite against anybody who is quote unquote a squatter. Even the way the court looks at those people, it chases them away. There was a time we were appearing in court and they were all told to sit outside. I don't know, wait outside. You don't need to be in court. You know, they like coming in big numbers and filling the court and all that. They were chased out. So there are some things that judicial officers do. They might be innocent in their action, but sometimes, the common person also has perceptions. They have the way they perceive things, and sometimes it's good to try and balance all this. So I think I want to stop there. There are other questions, but let me leave this at this point. Thank you.
My name is Christine Kimuli. My question is to the judges and magistrates. My question really is, what is the judicial attitude towards political decisions that deal with land? For example, when the politicians perhaps lobby or the executive makes decisions towards certain areas, ensuring maybe a certain tribe is dominant there, or to ensure also that perhaps indigenous tribe is not taken advantage of. So issues title in that way, even if there were other tribes that have come in and taken over the land legally per se. What is the judicial attitude towards that? Is the judiciary inclined to actually allow for purposes of public interest, or do they stick to procedure and perhaps cancel titles? And in that extent, especially at the coast when it comes to the land at the beach, which is indigenous in a way, but was allocated to maybe politicians or ministers during the start of government. How does the judiciary deal with that when it comes to the communities that are saying we've been here, but this land now belongs to politicians, and now they cannot even sue and they end up being squatters? What is the judicial attitude towards that? The politics of the country and of the time.
Maybe we can have answers to that. Then I'll take the last round of questions from Makuto, Mzame, and any other person who might have a question.
The parameters of granting stay pending appeal is informed under Order 42, Rule 6(1), and which we all understand is statutory, is security for costs, substantial loss, and whether you came in without any delay, and whether there's a good sufficient cause of action, Nyange. What we do observe is that we also want the person who has won the case to enjoy the fruits of judgment, but nonetheless we also want to safeguard the balance of scale so that there's a win-win. Now, what informs us on the matters of security for costs, we're looking at the value of the land. Yes, you could be representing a poor person, Mr. Nyange, but the land surely, is it worth that? Does it reflect that I wouldn't want to use the word poverty, that person of no means? That's number two. In the event that you feel that the security that you are being asked to deposit is punitive, or again is beyond your means, nothing stops you from coming back under 45. Review. We vary. We listen to you. Give me facts. I will listen to you. It's not cast on stone. Remember, I'm saying the others. There's also the judgment. Holder is also watching. Is also watching. So, so we must be fair to everyone else. So, but all the time you come back, we'll review. Now, matters of consent. Matters of consent, honestly speaking, from a personal viewpoint, is a challenge because consents are contractual in nature. And as you know, from the case of Laura Wasike and Destimo Wamboko, the Court of Appeal did indicate that the only time we can interfere with the consents if it's entered by mistake, omission, or misrepresentation of facts. These are factual issues. Honestly, to expect a judicial officer to go behind the scene and get to know what the parties are doing. Remember, there are two advocates who have appeared before you. I appear for the applicant, I appear for the respondent, and we are here to record a consent. Judge, please endorse it to become an order of court. If you refuse, again there's a problem. The other day, my sister Lena, sorry, with due respect, she was confronted with a similar matter, and she called me and indicated that here is land. This parcel of land, I know this matter was adjudicated. The person won the case. He has even gone, is out there, but I can see the title is back with the different advocates. And actually recording a consent. I have raised that issue, so I told her, just take the proceedings and make it as elaborate as possible, so that in future, and let them also submit, so that in future, should anything happen, at least you as a judicial officer, you'll exonerate yourself. I don't think there's any other, because a court of law, again, is not an investigatory. If you start again getting into investigatory arena, you'll find yourself into trouble. As far as Section 3 and Section 13 of the Environmental Land Act is concerned, your jurisdiction as what Masori was asking in the morning. We are so prescribed. Our work is very prescribed. So when you come for a consent, you just pray that one day, if the problem happens, then you'll come back and I don't know whether I'm answering your question adequately, but that is the limitation. On the issue of whether the municipal courts have powers for eviction, of course they don't have those powers, but it's abused. It's abused. So you as a party, you are the one to come forward and say that these are orders which were given clandestinely, illegally, and they need to be set aside. I don't know at what point, because by the time you're asking, maybe things will have gone south, but that is the much I can answer. Then I will still let my other my colleagues also who interact in those areas also do respond. Adverse possession, we are hardly giving orders. I think that's a blanket. I think from my presentation in the morning, you notice I'm very liberal. Only that the conditions are getting more and more tighter because people are abusing. That's one area. People are acquiring land very easily using the back door. And as you notice, there is even terminology now of the professionals quotas. So we also have to be careful, extremely, extremely careful. Otherwise, the courts will be misused as an avenue of acquisition of land that belongs to people who have indefeasible titles, interests, and rights over their land. Those are property rights also which we have to protect. Matters deciding a political Christine Kimuli, I'm hearing this for the first time. Courts are not political, not and they. They should never be. We are guided by the rule of law. It's very clear. The parameters are there. They are stated out. We don't even know. We don't. But there is a question that was even asked in the Baraka FM when we appeared there with Justice Munyao. Courts ni ya wabwanyenye. Sisi ambaye ni wanyonge, hatuna nguvu, hatukuji mahakamani. Mahakama ni ya wale wazito. I think that is a perception that is carried by some section, part of the section of the society. We are announcing, and we are announcing loudly and clear for those who are hearing us, the courts of law do not take sides. They shouldn't. We are just arbiters, and we are guided by the rule of law. We don't even, anybody who decides a case based on a political affiliation or inclination, then that is absolutely very wrong. The other day we were not even voting. We were, until we were advised this, you can vote, but you vote, that is the secret ballot, and you keep quiet. We don't even comment. We don't participate at all. So let them come. We'll hear their cases. I don't know whether you'd like to add something, Moy, or yeah.
There is a question on the judicial attitude towards squatters. Judge, let me, yes. Now, the nature of cases in Mombasa that we have to deal with, you have to agree that it is different. It is not the standard way in which these kind of cases come. For instance, you have a case where two individuals are before you. They are fighting over a parcel of land. Both of them admit that none of them holds a title deed, and all they have is letters. They have some contracts, most of them one paragraph long, written by a chief somewhere, saying that shamba hilo ni la fulani fulani, ama fulani aliniuzia hilo shamba tarehe fulani, and the other person also presents a similar document. And when you have to deal with these matters in the nature that they are brought, I think there is a bit of skepticism that develops over time, not deliberately, and not meant in any way to push the people from the seat of justice, but to be a bit reserved, so that you are listening to the individual with an extra ear. You are listening more carefully because you want to hear that which you are not being told. Because then at the end of the day, you make a decision thinking that all the information that is before you was the information that was to be had. And then after the decision comes out, you have those other allegations coming forward that the land does not belong to either of these individuals, and they were fictitious litigants coming, with a plan to snatch the land from the rightful owners. And I think that is not to say that the litigants are therefore being pushed away from the seat of justice, but it is to say that I think courts have become a little bit more careful while listening, and naturally you will give, you will give more stringent conditions. And I'm not saying, I'm not talking about what you're talking about, Mr. Nyange, that is stay pending appeal. But in many cases, you will even want to, even not at the invitation of parties, but even at the court's own motion, you will want to visit the place and have a look at it and have a bit more information before you make a decision. So the skepticism comes out of, past experience. Where you've been burnt once, you wouldn't want to put your hand there again a second time. So you are a little bit more careful when you are hearing these individuals. And then again, you are also alive to the fact that, sometimes there is even collusion that involves, unfortunately, sometimes the parties are aided by an advocate. And then later on, it comes to light that the land did not belong to any of the parties. In fact, they were just coming in once they got the injunctive orders, then they rushed in and they built Mabati houses over a weekend, and now they are seeking an injunction from those being demolished. So I think because of that, and because of the nature of the litigation that comes forward, and again, I think, as Judge was saying in the morning, this is all contributed to because of the historical factors that have contributed to all these, issues, to the disarray that we are now seeing when it comes to registration and ownership of land in the coast region. And so I think it shouldn't be interpreted. I think that is, I can call it caution. I think judicial officers have developed a healthy caution, a healthy amount of caution, so that they don't burn their own fingers. Thank you.
Maybe I think on the issue of adverse possession, I don't really have anything positive to report, because really what I'll say is that I've not handled any adverse possession matter, not here, not elsewhere. In fact, I was surprised when I came here, is when I learned that the lower court has jurisdiction to handle adverse possession. You'll be surprised to note that even in Nairobi, they don't file. They are not aware. I think it came after a judgment which was given in Nakuru. Yes, so in Nairobi and elsewhere, I think people have not yet learned about it. So the last time I handled adverse possession was when I was in practice as an advocate, which was quite a number of years ago. But otherwise, I hope to learn. I will catch up. Thank you.
I would like to ask this question, and it's related to Nyange. Nyange's concern about consents. Consent is becoming a very emotive issue in two ways. I remember as late as yesterday, I sent advocates, not once, twice. An advocate has written a consent has been duly executed, is sent to me, but only one advocate keep on coming. The other one doesn't appear. I have seen that as a trajectory, and I have insisted that let the both parties please appear. I know consents mean liquidation, because as a former practitioner, if you don't put money into advocates' pockets, then you are impoverishing them. And we work very hard to make sure that, and that's why we are telling the DR, speeding up on taxation matters. We want to clear matters quickly for you so that you go and earn your fees. I know if you don't earn your fees, those court orders really mean a lot to you. But again, now here is a consent signed by two, but only one person keeps on coming. And I have insisted both of them come. Eventually, they came, but I don't know whether I was tricked because they send now an associate of that law firm. What I do is that I record verbatim. I make it like a proceeding, so that in the event that anything happens later on, I'm forewarning you, Makuto. You say, these are the Mwakenyas, so that I'm not going to be held responsible later on. Now, my question to you is this, and again, I know banks will not bulge without a consent being endorsed as a court order, or in most of the institutions. What are the checkpoints? What are the parameters? What is your expectation as far as advocates, as far as consents, recording, endorsing consent is concerned? Because again, if we delay you from getting money. Again, if we do quickly, we end up what Kiage was talking about, circumspect. We need to be a bit more careful. You are putting us in a very awkward position. What is it that you want us to do for you that is legal?
Yeah, I think to just what I would call pointers is to look at the nature of the consent. You know, it is not possible that I have sued you, and then the thing to do you do is you file a statement of admission. I mean, really, if you're admitting, why don't I resolve the problem for you? If it's title, let me just sign the transfer for you. If it's eviction, let me remove my structure and walk out. Why would you need an eviction order by way of consent for me to vacate? You see, so those are, in my view, pointers that there is a problem somewhere here. Or instances where someone has gotten an injunction, came under certificate, gotten an injunction, and then by consent he withdraws he withdraws the entire suit. You see, I mean, does it really make sense? Then he just files a notice of withdrawal, and then once the court to come and it doesn't even serve. You know, now this person has come under certificate, gotten an order of injunction, and he has, you can see the application has photos of houses, permanent buildings, you know. Then after 2 days, there is a written withdrawal of the entire suit, meaning even that injunction is collapsing. And then after that, you see it in the newspaper that the entire place has been flattened. It means there is something wrong. You just, if you look at the pleadings and the paperwork, these land cases, sometimes you don't have to be in a big hurry. Even if you're being pushed, especially where there is a push, oh, record this, accept this, just think and you'll just find that there's a problem somewhere. So there are some consents, I mean, really a consent to extend time, you know, those ones are okay. But the nature and the manner of the consent, the way it appears, it is telling in itself, and in my view, it is enough to warn the court that there's a problem there. Thank you.
Thank you. I think we now need to close our program, but I will just, Uzame has been raising his hand here, so maybe I'll just give him a chance. Yes. Okay. But judge yourself, you're still here for the one question. I think we can release our two magistrates and then you have the two questions and we close. Okay. Chair, vote of thanks to the magistrate.
Thank you. I think we had done the final ceremonies earlier, so mine will be to thank you and to wish you well where you're traveling, and Wish that you survive well during the weekend so that we can meet on Monday and continue our usuals. Thank you very much. But while holding the mic, since there are many angles to look at that issue. Number one, it shows you that there's some collapse in the system and not blamable on any particular individual. The courts and the law have made it very hard to get eviction orders, even where they are deserved. The law has made it very hard for anyone to move court and evict people from his land and be able to go and do development or whatever they want. So it is true, and I can tell you for a fact, it is true that sometimes people cause themselves to go and be charged at the municipal court in order to remove some structures which are actually also they are illegal. And the municipal officers also are very glad when you report yourself. They'll give you notices to comply and vacate, or they'll come and demolish at your cost. And what they are demolishing is something which is an illegal structure. So all of you are doing the wrong thing, but trying to comply with the law the way it's supposed to be complied with. It's a shorter way, a neater way, but you achieve results quicker, although in the unconventional way. So those consents, those agreements are good. And you can see here we are talking about a whole county council or a county system agreeing to that arrangement. Number two, sometimes also the advocates aid their clients, and I'm just being honest, they aid their clients and collude with the other advocate to deal with the nemesis that is stopping development going on that property, and development in quotes because it's development in accordance to the advocates. They want to deal with this issue because they know if we attempt to go through the court system and go there claiming we want orders of eviction and whatever declaratory orders we have, you will stay in court for 9 years or 10 years through the judicial system up to the Court of Appeal. So one better way is sue. After you sue, get a consent. After you get a consent, evict each other or something like that, and everyone goes home happy, including the advocates. And even the court is happy because the matter is resolved quicker. Yeah. So, and these are consents dealing with the rights to title. I'm not saying normal consents of amending whatever. I'm just saying the gist. The problem is that getting orders of eviction or getting orders to do with vacant possession is a nightmare everywhere in the country, not just in Kenya. And these things, not just in Coast, and these things happen everywhere. Even in Nairobi, I know similar things are happening there. So it is actually an answer to the saying that nature abhors vacuum. There's a vacuum in terms of how to get quicker dispensation when one is faced with such situation. People invade your land. They are there. You have tried all ways and you can't. They have built structures there and they are continuing. And then you get an order for status quo. You take to the police, you whatever. Then the police tell you, but this order is saying that we actually let these people continue constructing the way they are or living the way they are. So you go away. There's nothing you can do. That same order of injunction or status quo you give assists these invaders to actually invade and do more injustice to your land. There was one land up here where the judge gave orders, Justice Ibrahim, and in 2 days, 3,000 people had invaded and had built. And actually, a whole police force and whatever had to be mobilized through the judge's own supervision in order to evict them again. So that's the nightmare that people deal with. Thank you.
So And Bosco a chance to ask their questions.
Muzame from Olot Kemori and the University of Nairobi. So my question is on the jurisdiction of the ELC on transfer, whereby the jurisdiction to transfer a file is granted by Section 18 of the Civil Procedure Act. And now you have the same Civil Procedure Act defines the court to mean the High Court. The Interpretations and General Provisions Act defines the High Court as the court established under the Constitution. Therefore, my question is, where does the ELC get its jurisdiction to transfer a matter between, say, I've filed a matter in Mombasa, and I want due to, and the issues are in, say, Kwale, and I would want the matter, the file transferred to Kwale because it's it's in proximity to the land in dispute. Where will the court derive its jurisdiction? Thank you.
Again, Bosco Juma. First, I wanted to comment on the AJS. I happen to have sat in community council of elders. They call them Magogo in the villages. And my comment is, first, they deal with quite a number of issues. And at times, as it is, any case from the community, they refer it to the police. And police, in some cases, they refer those cases to the village elders. And those cases, some of them are those that qualify to go for to be court cases. And in that, I was commenting in the sense that AJS have a strong role to play. And I'm seeing there's a kind of a gap, given that most of the village elders who play such roles don't get opportunity to sit with great minds like those in this space. But then again, they still need to be given more of awareness in regards on how AJS work and the role that they play. On my second question is, given that we work in restoration programs, and we always meet cases, especially during COVID-19, cases of illegal logging, mostly with communities and just people who want to make a living from cutting trees. And in some cases, we have been able to take them to court. And for example, for those who are aware with the trees, they take long to grow and they are of high value, especially in the likes of mangrove. And someone can cut, like, let's say, a couple of trees worth good amount of money. You struggle to take the case to court, and what happens? The judge or the magistrate just and the person is told to do a community service or to give just cash and then goes away with it. And we feel how the court interprets such kind of cases, or the criminal system, how it looks. It doesn't value the trees, and it considers such crimes as a petty offense. I don't know how judges look at it, or we need to go and then reorient in such kind of cases so that it gives us the value that it deserves. Thank you.
Uzame, the issue of jurisdiction, and I'm happy that this is a matter that have been discussed from morning to now. Don't be tired to hear it again and again. My colleague Mwanyale did emphasize on the case of Karisa Chengo, Malindi. But to begin with, the court is a creature of the Constitution under Article 162B of that Constitution, which gives the court unlimited original jurisdiction. This court, in as much as it's a specialized court like ELRC, Employment and Labor Courts, is a court of equal status with the High Court. So at no one time You only remember that you are in ELC because you are dealing with ELC matters as dictated by Section 313 of the Environment and Land Court Act of 19 of 2011. But nonetheless, everything else, and you appear in that court. Sometimes I even forget whether I'm in environmental land court because I'm using the civil procedure. That is the substantive law that I use. I mean, this procedural law I use, law of evidence, all manners of the laws, all things that are clothed in a high court are the same. So the fear you have about where the matter should be transferred, if I'm transferring, I go to 18 of the Civil Procedure Act, and I do that. And we've done that so many times. So that should not be an issue at all, at all. So we are court of, actually, if anything, is the High Court, quote unquote, who are making efforts to take away our jurisdiction. You had the cases of Peter Kangede. To us now, we are saying as brothers, we think our brothers are taking, they think we have too much that they want to take away, so that they're also looking busy. Of course, they don't want to hear me, but that's a conversation we are having. Because we have said, surely, what is this business about commercial matter against a land matter? It's like saying a cup of tea, separate the milk and leave me with the sugar, and take separate tea, milk, sugar, and tea leaves, and they're all in the same cup. This is a land matter, is our matter. Let us do our job. You do your job. It's unfortunate that these specialized courts were created. In 10 years, we thought we'll collapse, but 10 years is still going and we are getting stronger. But those are the politics of the judiciary anyway. I hope you're not bringing those politics here. Because it's heavy, I can tell you. It's just the other day that we are allowed to have a principal judge and so forth and so forth. Now, the matters of logging of trees, those are criminal offenses. They are in the penal code. It's just our penal code needs to be, is archaic, it's too colonial. It has refused to grow. It has refused to pick up with the times, as what council was saying in the morning here, vis-a-vis section 106 A of the Evidence Act. Evidence Act is an old act, and I was talking to a professor of a lunch hour who is lecturing Evidence Act. Evidence Act is growing at least, but penal code has refused. It is still the same old colonial. So the magistrate looks at it and says, okay, the only penalty I can give you, it looks like is a petty offense. Surely I can't take you to just do communal work, community work the whole day. It's not looking at the tree, the logging, the bigger picture. It's looking at the offense which is prescribed in the penal code. I was just looking at the social media today. Somebody has cut trees full, fill it in a lorry, and there's a very big writing there, please plant more trees. So you wonder, this guy is cutting trees and it's still saying that you plant more trees. So that's basically the reason, but I want us to build that jurisprudence. If that power was given to the ELC, I can bet with you, those people will go to Shimolatewa, they'll spend some time there. The president is suffering, planting trees. You had his speech for almost, I think took almost 30 minutes talking about planting of trees. So if you cut trees, why do I make you just wash the, cut some grass in the court? So I agree with you, it's the penal code. Yeah. But this jurisdiction business, I think, I'm seeing like there's a bit, it's a conversation that is going on in very many forums. People are trying to destabilize us, but we have refused. We have been getting stronger. Yeah. Okay.
Yes, we've now come to the end of the program, and I invite Chairman to come and appreciate our good judge and our very own Mr. Dala. And thereafter, Chairman, you'll just proceed to close the program with some closing remarks. Thank you. Judge. Sorry, Judge, they're just trying to set up something. So maybe Chair can just do the closing remarks first, then we'll do the appreciation.
What are they setting up? Oh, okay, thank you, ladies and gentlemen. Judge, on behalf of the other judges who have been here, on behalf of Mr. Balala, Mr. Ochieng, I think there was Mr. Ochieng before I came, Mr. Adala, Mr. Kiage, Mr. Mburu, Griffins, yeah, I was looking for the name, Griffins Ochieng, and the members who have been so patient from morning to attend this function. I really thank you for having accepted to come and attend this function. I also cannot forget Ms. Njao, who is in the UK, for the participation that and the efforts she has put in. Kituo cha Sheria, Mr. Nyange, we really extend our thanks to you for collaborating with the Mombasa Law Society to be able to make this day a success. We have had a very rich and robust engagement. As you can see, the topics that we've been discussing we are just scratching the surface. We actually need more time, more days, more space in order to be able to exhaust some of these topics. And even then, I know there'll still be emerging and new challenges and new areas. What I'm speaking to is that knowledge is not static. Every day that we are at it, we are learning something, we are exchanging views. There is nothing like a younger person or an older person in terms of acquiring knowledge. There's nothing like this is a lawyer, that one is a so-and-so. We acquire knowledge from each and every one of us. When I go to the village, I get so much from my grandfather, my grandmother, some of them who have never stepped in school, some of them perhaps who are not literate enough, but they give me some wisdom and solve some very complex issues. If we work with each other as stakeholders, as people who are interested in the same outcome, a just society, we are going to be able to deliver a just society to our people and to ourselves. It is only us who are living on this earth. If we do not maintain the environment, we can only blame ourselves again. Our forebearers did it for us. What about ourselves? What are we doing for posterity? It is our duty, through such encouragements, through such seminars, through such talks, to educate each other to know that this environment is ours and we benefit from it. I thank everyone for having found time to come. I can't be able to mention all your names, but please, anytime we call for such meeting, I think I'm impressed today, and I hope that any other time we call for such meetings, you will be able to come. Judge, I hope you will favor us with your presence whenever we come and disturb you and meddle in your time, so that we can share a lot the way we have shared. In Mombasa, we believe in collegiality, we believe in talking to each other, and we believe in, because that's the only way we can advance ourselves. I really thank each and everyone, all the organizations who have been supporting us. Kituo cha Sheria, we really thank you. And I think we are going to organize more and more of such engagements. And I hope all of you shall be able to join us. Thank you very much, and may God bless you, and have a nice weekend and a nice future too. Thank you.
Yeah, I know as a matter of protocol, we don't speak after the chair has spoken. So I'll make it brief to the point. One is I am actually very fascinated, very thrilled since I came to Mombasa in August last year. The interactions that I've had with the lawyers, MLS, is overwhelming. I have my 22 years in practice. I have never interacted with the judiciary until almost the years when I was put in the CUC. That's when. So here I find it very unique that judges and advocates can interact so easily. And at one time, no point have I been asked take care of my file when I come before you. You are very professional. I must congratulate you for that. You are very, very professional. And that gives us encouragement because I think most of the reason why colleagues fear coming, they feel maybe you come over here and you'll compromise your work. I've had this, that is not in Mombasa. Come here, sit, discuss, and we leave. And then on Monday, tomorrow, if you are not, your witnesses are not ready, too bad. And I know I have dismissed a couple of cases here, and there's no bad feeling really. It's just the timelines. We want timelines. Even you'll enjoy. That's how you put money in your pocket. So don't keep on adjourning matters and be honest. I mean, if you come to me and you have an honest reason, honestly, just tell me I have fatigue, judge. I can't hear a matter. I will grant you. Please let us be honest to each other. That's one thing I would like us to do. And let us continue interacting. Let us continue. I want to thank you so much for picking this topic, the green injustice. Honestly, I feel favored, and not only personally, but even in Nairobi. They are watching the proceedings right now as we speak. They are very excited. We have the 10-year celebration in Kilifi. We've been blessed. We had to take it to Kisumu, but the gods in Mombasa prayed harder, so it's brought here. Now, the reason why I'm bringing that issue of the 10-year, I've been sent, I have a message that MLS kindly, I've said with the convener, that get somebody to do a presentation, do a paper or something, discuss your activities during that conference. You'll be invited formally. And then finally, so that I wind up, I had apologies from my colleagues. I'm not the only ELC judge. I'm actually ELC 3, which means we are 3. There's ELC 1, S. Kibunja, is in Naivasha, working on some strategic plan for the ELC. And also we have Justice Matheka, ELC 2. They also sent their apologies. Mmezipokea? Also Justice Sila Munyao. By the way, it's actually Sila who was supposed to have made the presentation. So I was holding his brief. So just be knowing if you didn't know. Thank you very much. Asanteni sana. And I thank all these small gifts. I hope they're not 20,000 shillings, so that I'm not saying that I've taken something inside here. With a light touch, Asante.
Okay, thank you, Judge. At least we can assure Judge that this is the way we do it in and from times immemorial, from the times of the Chief Justice Mutunga, the Chief Justice Baraga, even before, even during Gisheru's time, even when I was in the judiciary. So it's a tradition of Mombasa. Thank you. Okay, you are all now dismissed. Okay, let me have a prayer warrior here. Mr. Lukman, please come. You are the one in the council. Yeah, and it's a Friday, a holiday. So I'm told there is tea, although Lillian has been holding, she has not told me that. But if there is tea, it has to be taken. Maragolis, take note.